go. I'll let you know in real life. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. So good morning, Council, and welcome to the Massachusetts Appeals Court oral argument session for March 12, 2021. As you know, this argument is being held on Zoom and simultaneously live streamed on the Appeals Court's YouTube channel. The panel for today is Justice Vicki Henry, Justice Joseph Ditkoff, and myself, Greg Masson. We will follow the same rules and customs as in the physical courtroom, except you may remain seated if you prefer. Once we get going, the session clerk will display a countdown clock. As usual, each side gets 15 minutes. There's no rebuttal. You're welcome to use all your time, but there's no penalty if you finish early. And while one of you is speaking, the other will be muted, but we ask you to please stay on the video, and yet at the same time, remember we can see you, so please keep your reactions to a minimum because that can be distracting. The proceeding is being recorded and archived and will be accessible to the public. As always, we've read your briefs and we're familiar with the case. In fact, we have your briefs and record materials on our computers and tablets, so if you see us looking away, please no disrespect is intended. We are actually just looking at the case materials. So with that, I'll call the first case, which is Commonwealth versus a juvenile. And since it's a juvenile case and it's impounded, let's not refer to anybody by name. It's 2020 P40. Attorney Katz representing the juvenile.
Good morning, Your Honors. May it please the court, Daniel Katz for the juvenile. The adjudication of delinquency cannot stand in this case because the judge relied on inadmissible totem pole hearsay that was damaging and prejudicial. During this case, 2 officers approached the house where the juvenile lived, but only one testified, and that was probation officer Bonnie Vonasek. She set the scene for that evening. It was chaotic. The juvenile was there. The juvenile's mother was there. The juvenile's sister were there, and there were other kids there in the yard in front of the house. And I'd like to call Your Honor's attention to pages 12 and 13 of the transcript, because I think that's where this issue is laid out.
Attorney Katz, can I ask you, are you making a legal claim or a factual claim? Are you? We've all read the transcript, and those 2 pages are pretty easy to get to. And it looks pretty clear that the probation officer is there live in person hearing this happening. She says he was angry, he was yelling, he was swearing. And she was right beside the police officer when she was speaking to him. So are you saying that as a matter of fact, she was told this by the police officer? Or as a matter of law, it's totem pole hearsay if you're not being spoken directly to?
To both factual and legal, Your Honor, because if you look at the transcript there is a moment where Vonasek is standing next to Detective Cronshaw. But then I'd like to call Your Honor's attention to the question that the prosecutor asks. And that's right in the middle of page 12, and I'm going to read it because I think it's very important. The question is, now, at some point, does Officer Cronshaw interact with the juvenile? I would like Your Honors to notice that the prosecutor does not ask, now, at some point, does the juvenile interact with both you and Officer Cronshaw? The prosecutor specifically asked about a conversation that took place between Officer Cronshaw and the juvenile.
But questions aren't evidence, answers are the evidence. And the answer is, he was mad at that his mom and his sister were telling us about his behavior. He was mad that his sister told us that he had hit her.
If you look at that, Your Honor, the us is actually referred to. The us is both Vonasek and Detective Cronshaw, but the us is what was being said by the sister to Vonasek and Cronshaw, not what the juvenile said to Cronshaw and probation officer, right? The answer is yes. The juvenile started, it should be stated, he was mad that his mom and that his sister were telling us. So the us is that it's the sister telling the probation officer and Cronshaw. It's not the juvenile telling both of them. So what you have, Your Honor, and it's not clear from the transcript whether Detective Vonasek was overheard. And I understand, and you realize, of course, that that is the key issue. Did Officer Vonasek overhear the interaction, or we can say conversation, that occurred between the juvenile and Detective Cronshaw?
Well, so
And-
do you agree that if she heard the juvenile say that to Cronshaw, then she can testify to it?
Yes, if she overheard. But as we know, the proponent of the evidence, that is to say here, the Commonwealth, bears the burden of showing the admissibility of the evidence. And the judge, if we look towards Mass Guide to Evidence, Rule 104A, where the judge is supposed to make a preliminary ruling about the admissibility of evidence, the judge only covered part one. That is to say, the statement of the juvenile. Yes, if Cronshaw had testified to what he heard the juvenile tell him, that would have been admissible as an admission of a party opponent. But what we have here, and because the transcript isn't clear, and therefore it's not clear, and when it's not clear, we look to who has the burden of proof to show the admissibility. And it's the Commonwealth, because they were the proponent of this evidence. And the judge failed to look at, determine whether that second part, whether that second statement, the conveying of what the juvenile said to Cronshaw, we don't know how those statements got from Cronshaw to Vonasek, making Vonasek able to get on the stand and testify. If we look at the transcript, it is not clear. At one point, Vonasek is standing next to Detective Cronshaw, right? And I know questions are not evidence, but the way that the prosecutor has framed it, the question is a direct response to the question, and the question does not say, does not ask, immediately after you were standing next to Detective Cronshaw, what did the juvenile say to both of you?
What about the part at the bottom of page 13 where the prosecutor asks, they're talking about the statement that he's going to kill the sister. Where were you when the statement was made? Right next to him and Detective Cronshaw.
Now, Your Honor, we are talking about three statements that are part of this case. The first two are the ones that I am arguing that were admitted in error as totem pole hearsay. Those are statement one, the sister saying he was mad that the two statements that the juvenile said to Cronshaw. He was mad that his mom and that his sister were telling us about his behavior, right? That's the first one. Second one, he was mad that his sister had told us that he had hit her with a rock prior to us being there. Those are the two statements that I am challenging that were erroneously admitted as totem pole hearsay. The third statement is the statement on which the juvenile is alleged to have threatened the sister. That is, if you look closely, and I know you will, Your Honor, at pages 12 and 13, that is a separate statement, and that is what the judge considered the threat. And the judge, if you look at her ruling, you see that she specifically mentions, well, it wasn't just a general threat of I'm going to kill the sister. The judge uses those two statements to decide that this is the intention of the juvenile, the intention being one of the required elements that the Commonwealth must prove in order to garner.
Counsel,
Sorry, Your Honor.
why couldn't the judge on this record find that it actually was one statement containing all three of those elements?
Because the evidence is just not there, Your Honor. First, when the prosecutor asks, okay, at some point, Officer Cronshaw interacts with the juvenile, and then Vonasek is on the stand, and she mentions two statements that the juvenile allegedly said to Cronshaw. Those are separated out in the transcript. If you look at pages 12 and 13, that they are separate from that third statement where he is alleged to have threatened to kill his sister.
They're all the answer to one question. All those things are the answer to one question. They're all put together by the PO. Why is it unreasonable for the judge to think that that is one statement that the juvenile is making?
It's unreasonable because if you look at the transcript, it's laid out in a time frame. It's a short time, that is true, in terms of when the officers arrive at the juvenile's house, but they're laid out in evidence as two statements that were allegedly made by the juvenile to Cronshaw. And then Vonasek is then talking about a third statement that contains the alleged threat. To me, Your Honor, it's clear in the transcript, if you think about it as a timeline, it all happens relatively quickly. But Vonasek sets the scene in that there was a lot of yelling. It was chaotic. There were other kids in the yard. So I think if you look at the fact that the Commonwealth, being the proponent, has the burden to show the admissibility of the evidence, it's not clear, it's not more likely than not that Vonasek overheard what the juvenile allegedly said to Cronshaw about being mad at his sister and his mother, and the judge used his being mad about his sister being a so-called tattletale and his mother being mad at him. And the judge uses that as the premise to say, well, this general threat wasn't just, I'm going to kill you, my sister. I'm going to kill you because you tattled on me. And if you take away those two statements, the judge clearly says that she is relying on those statements that I am currently challenging that were erroneously admitted as totem pole hearsay.
Counsel, I want to make sure we get to the sufficiency argument. So if you have anything else to say before I ask about sufficiency?
No, I'm happy to take your question, Your Honor.
So in the third element of the circumstances that would justify apprehension on the part of the recipient of the threat, do we consider only the exact moment when the threat is made, or do we consider the ability in the near future?
You consider that moment, and you consider the near future. That is true. But if you look at the totality of the circumstances, And I would urge your honors to look at the cases that I cited by this court and the Supreme Judicial Court that specifically mention the what the object of the threat was feeling is actually relevant, even though the Commonwealth doesn't have to prove that the sister actually felt fear or apprehension. Clearly, this court and the Supreme Judicial Court, in the cases I've cited, have gone out of their way to say, well, it can be relevant in determining whether there was fear or whether a reasonable person in the sister's shoes would feel fear or apprehension. And so, yes, the sister did not testify, but the mother testifies that she was, angry and yelling. There's no evidence about the sister shaking, about being scared.
No, but what we have is a juvenile who's done enough to be on a 5 p.m. curfew, a 14-year-old 5 p.m. curfew, not 7, not 8, not dusk, 5 p.m. So we know he's got a history. He's out of control enough to make a threat in front of law enforcement when he already knows they could take him in because of his curfew violation. And we have the element of snitching, and we seemingly also have that he's already hit her with a rock. So why is that not enough?
Your Honor, if you look at those statements, there's no other evidence that there was a rock involved. The snitching, the word snitch, actually, if you look at that third statement that I'm arguing is a third statement, Vonasek does not recall the specific words, and she mentions, well, he threatened to kill his sister for snitching on him, basically. So we don't even know, and given the fact that the Commonwealth bears the burden, we don't even know if that word snitching was actually used. And quite frankly, it's unfair for this court, given the fact that the Commonwealth has the burden and Vonasek doesn't even remember the words of that threat, for you to assume that A, the word snitching was used, and B, the word rock is only in those two statements, which I implore your honors were actually erroneously admitted in evidence as totem pole hearsay.
Okay, I think we got that. Your time is up. So unless there are other questions, we'll hear from the Commonwealth.
Thank you, your honors.
Thank you.
It please the court. Good morning, your honors. Jason Haran on behalf of the Commonwealth. The Commonwealth, your honors, submits that the court did not err in denying the juvenile's motion in renewed motion for required finding of not delinquent for the threat to commit a crime charge, as the Lattimore standard, the light most unfavorable to the Commonwealth. Any rational trier of fact could have found that evidence that a reasonable person in the sister's position would fear the juvenile would carry out that murder. As the court indicated, there is a totality of factors that the court can take into consideration and took into consideration when this court made its ruling in denying both those directed verdict motions. So as Justice Henry indicated, the Commonwealth suggests that the Commonwealth versus Milo M, the court can take into consideration the near future. We have a situation here where the juvenile is yelling, swearing, chaotic situation. Everybody's tempers are flaring. Everybody's in close proximity to each other, and a threat is made based upon the sister snitching on the juvenile. So the Commonwealth suggests, your honors, that there is sufficient evidence presented to any rational trier of fact at this point. And the judge—
What do we do with the fact that siblings sometimes say terrible things to one another and don't carry them out, I would say, in an overwhelming number of circumstances?
That's a fair point, your honor. This situation, based upon the totality of the circumstances, the Commonwealth suggests that there could have been a threat that was carried out at this point. And the alleged victim, the sister, the that the juvenile made a threat under circumstances which could have reasonably caused the person to whom it was conveyed to fear that the defendant had both the intention and the ability to carry out the threat. Commonwealth points to the judge's specific findings, Your Honor, where the judge specifically goes through each element and makes the facts and applies those facts to the law. And we assume that the court in a bench trial instructs herself on the law in a bench trial.
Counsel, let me ask you this.
Yes, Your Honor.
If a reasonable person would be in fear, not of being killed from this threat, but of being injured, of being a victim of an assault and battery dangerous weapon from this threat, but wouldn't reasonably think that they actually would be killed by him. Is that enough with the way this case was tried?
If let's say if it was a threat to, I'm going to beat you up, Your Honor, or
someone says, I'll kill you, like this juvenile did. And a reasonable person would take that not as a threat to actually kill them, but as a credible threat to harm them, but not to actually kill them. Does that work in this case?
I'd say yes, Your Honor. I'd say given the circumstances, as Justice Henry pointed, that this kid is we're coming up to a situation where one police officer, one PO are involved in a situation where they're checking on the curfew of this juvenile. He's past his curfew. The juvenile's upset. He's agitated. Everything's becoming more and more chaotic with tempers.
I guess my question is more a legal one, where the complaint says to wit to kill.
Yes.
Does the Commonwealth have to prove a reasonable fear of being killed, or is it enough to have a sort of lesser included of a reasonable threat to suffer an ABDW or an assault and battery?
I think we would have to prove that no matter what the crime, whatever it was, whatever the threat and allegation was, would constitute as a crime. So I would think murder would constitute as a crime, ABDW would constitute as a crime. I think that's the Commonwealth's burden at this point, Your Honor, whether the alleged threat or the threat would constitute a crime if it was in fact carried out.
So counsel, in an ABDW, to wit a knife, the knife is actually not an element. The particular weapon is not an element. So is it, I guess I joined in Justice Ditkoff's question about whether or not the to kill part versus commit some other crime of bodily injury would be sufficient.
In regards to element number three, that the injury was threatened if carried out would constitute a crime.
Yes.
Yeah, I think any crime potentially could be significant enough. I mean, you're right. We wouldn't have to prove assault and battery, dangerous weapon, the to-wit knife portion. But if he threatened somebody with a knife, maybe assault with a dangerous weapon, or to threaten to kill. I'm not sure. I'm particularly sure I'm understanding fully the question, Your Honors. I apologize. But I think anything that would constitute as a crime would be sufficient enough to meet element number three. That being said,
so it's a, the part we got it. The Commonwealth has to prove a reasonable that the subject of the threat has a reasonable apprehension that the defendant might carry it out, could carry it out, and that's almost like asking for propensity evidence. What kind of what kind of evidence can the Commonwealth use to show that he actually could carry out a murder?
Well, that's a great question, Your Honor. And that goes to the defense's counsel's strategy in this case. I mean, excuse me. He argued that there was no prior bad act submitted, but that's not an element of the crimes, Your Honor. So Commonwealth suggests that this is an objective standpoint, whether the threat by its contents and the circumstances as such would cause the target of the threat to fear that the threatened crime and injury might be inflicted. So based upon it being an objective standard, I think the fact that the victim didn't testify was irrelevant in that there was no findings based upon the court's ruling that any subjective input was displayed by the judge. So I think propensity evidence would help to prove that, Your Honors. However, I don't think that's
inadmissible.
What? I'm sorry.
Propensity evidence is clearly inadmissible.
Correct. And if the court's directing towards the prior bad acts, I think I correlated the propensity with the prior bad acts. I apologiise.
Right. Okay.
But that's what he argues, and he argues further in his closing that this is a hyperbole. These are just words. I Commonwealth suggests is a reasonable defense given Commonwealth versus Scholey, but it's not an element. We don't need to prove an additional element of a prior bad act or prior propensity evidence.
But why aren't these just words? You know, in a sibling situation.
So, in this situation, Your Honor, I would suggest the totality of the circumstances of the factual basis that B.O. Bonasek testified to. And that is sufficient, and Commonwealth suggests the court did the same thing in Commonwealth versus Milo M., and that's 433 Mass 149, particularly in regards to the prong number 4, element number 4, and totality of the circumstances, the juvenile's behavior, the juvenile's conduct, the number of people who are around, P.O. Bonasek trying to de-escalate the situation, juvenile appearing agitated. He keeps escalating during this time. The sister and the mother are in close proximity to one another. So I suggest that this, in light most favorable to the Commonwealth, any rational trier of fact could have found the juvenile delinquent. And that's in fact what the court found, based upon the evidence and testimony that she found credible. So, and again, we have the objective standard.
So turning to the hearsay issue.
Yes, Your Honor.
This was not a model of laying a foundation here.
That's correct.
So, you know, why do you think there was enough, and whether you agree with it or not, counsel's divided this up into 3 statements. You know, why are, it does seem like there are some inferences and holes the judge is filling in. Why is this acceptable?
So if I may, Your Honor, the Commonwealth suggests that in taking the record in context and interpretation, the Commonwealth's position that it is not hearsay, it is party's opponent's statement. And that is even, Commonwealth suggests, even after the judge inquired with the witness about whether these statements are the juveniles. And then,
right, I know, but if Cronshaw said, they get back to the station and Cronshaw says, can you believe what this kid, he said, blah, blah, blah. And the judge says, you know, and then the probation officer repeats that at the trial and the judge says, were those the statements of the juvenile? The answer of the probation officer is going to be yes. Because but that would be complete hearsay and inadmissible if she didn't hear them.
Well, when I think the fact that she answers in plural format, as Justice Massing pointed out, I interpret this to read, I'm mad because my sister and mom are telling them about my behavior, or I'm mad because my sister told you that I hit her with a rock, and therefore you're snitching on me, therefore I'm going to kill you. And then we have a situation, and I think we could take these statements in totality and not separate them. I think that is a point that the court should take into consideration, the chronological order of the situation, escalating, P.O. Bonasek trying to de-escalate the situation, her remaining calm, and then these statements are made. But it's the Commonwealth's perspective that it's not hearsay, it's a defendant's party's own statement offered against that party.
Right, but the issue is the Commonwealth has to lay the right foundation. And can you understand that this is not a model foundation and is not what we would want to see?
Yes, I do understand that, Your Honor. Absolutely, absolutely. And I completely agree that the next statement, it says she's on the scene. I suggest she is in close proximity. I think it's a reasonable inference that she did hear these statements based upon her being on scene and being in close proximity to the juvenile when he's yelling, shouting, swearing, etc. But it's not the it's not the model foundation. Absolutely, Your Honor, I agree. But I think if we take the reasonable inferences and the totality of situation, circumstances, P.O. Bonasek present, I suggest to you that it's a party's own statement offered against that party.
Is the statement his sister told us that he had hit her with a rock? Hearsay.
The statement on 12 line 16, Your Honor.
Yeah, it starts with he was mad, but then that his sister told us that he hit her with a rock. Is there any of it? Do we have evidence actually that that he hit her with a rock? Is there any evidence that he hit her with a rock on this?
No, there is not, and that would have been that's correct. There is no evidence that he hit her with a rock, but I interpret that as he was mad that his sister told us that he hit her with a rock. So I'm mad because my sister told you I hit her with a rock, is the statement of the juvenile.
So it could be, we don't know if it's true or false whether he hit her with a rock, but he's mad that she made the statement, whether it's true or false.
That's my interpretation of it, Your Honor, yes.
But so if we don't have evidence that he hit her with the rock, doesn't that actually hurt on the sufficiency?
Sufficiency of the threats?
Yeah. If what we can't say, oh, and he's going to kill her. He'd already hit her with a rock. Actually, we don't know that he hit her with a rock.
Right. That's a fair point. We don't know that if he hit her with a rock. There was no evidence or testimony to suggest that. It's just juvenile's own admission, the Commonwealth suggests. So I'm not sure if the court can take that admission because there's no corroboration as a factor, but given the totality of circumstances, the situation outside of that statement, Your Honor, I suggest there is sufficient evidence that the court heard. So if there's no further questions, I rest on my brief and I thank you for the time.
Seeing none. So yes, thank you both. Interesting case, and we'll take it under advisement.
Awesome. Thank you, Your
We are live and on the record.
Thank you. So good morning, council, and welcome to the Massachusetts Appeals Court oral argument session for March 12, 2021. As you know, the argument is being held on Zoom and live streamed on the Appeals Court's YouTube channel. The panel for today is Justice Vicki Henry, Justice Joseph Ditkoff, and myself, Greg Massing. We will follow the same rules and customs as in the physical courtroom, except you may remain seated if you prefer. Once we get going, the session clerk will display the countdown clock. Each side gets 15 minutes, no rebuttal. You're welcome to use all your time, no penalty for finishing early. And we'll have the person who is not speaking on mute while the other one is speaking. We ask you to stay on your video so we can see you're here, but at the same time, since we can see you, please keep your reactions and gestures and noddings to a minimum because that can be distracting. As you know, the proceeding is being recorded and archived. It will be accessible to the public. As always, we've read your briefs. We're familiar with the case, so you can jump right in. In fact, we have your briefs and record materials on our different screens and tablets before us. So if you see us looking away, it's not that we're not paying attention, it's that we're looking at the case materials. So with that, I'll call this case, the second case for today, Commonwealth versus OMAR Enriquez, 19P1794. And if I'm pronouncing it right, it's Attorney Suchecki for the
Suchecki.
Suchecki?
Suchecki.
Suchecki, you have the floor.
Right, thank you. Good morning, Your Honor. Mr. Enrique did not receive a fair trial based on the fact that a document was submitted and allowed to be submitted by the Commonwealth that substantially swayed the judgment in this case. The document called Set in Stone was objected to when it was proposed. There's a motion to eliminate to exclude it. There was an objection when it came into evidence, and this document was it came after the complainant turned 16 years old. It was very close in time to when Mr. Enriquez was arrested. And it is a document that is so inflammatory that it swayed the jury's, or potentially swayed the jury's response to it, their response to the evidence in this case. Because of that, because it paints Mr. Enriquez as predatory, it's salacious, it's deviant, it's kinky. And because of that, the Commonwealth, as any good lawyer would do, exploited that. In the opening statement, in fact, the Commonwealth stated and misstated the evidence that happened in the previous case, and said that it was a relationship. It's a dominant submissive relationship that the document purports to say that Mr. Enriquez is trying to get with the complainant, and in such a way that in the opening he misstated, said there was a relationship that he was actually looking for, and that was not the case. And when it came in opening statement, defense counsel objected and asked for a very forceful instruction, saying to specifically mention the document, because he knew he had to confront that document, and asked the judge to put a forceful instruction in that he not be allowed, and that he had misstated the evidence. The judge refused to do that, instead gave a tepid kind of standard instruction that opening statements were not evidence. When the evidence came in during direct testimony, the complainant specifically said that the document was not designed for her and Mr. Enriquez.
On that point, though, she testified that the document was more for mine than the current boyfriend. And Commonwealth, of course, then argues, well, if it was more for, that means that there was some room that it was also for her relationship with the defendant. What do you say to that?
I think that you have to, there's a presumption there. You have to, if the judge was actually wanted to explore that further, he could have asked, taken her aside and examined her one-on-one. But it's equivocal. It doesn't necessarily say that. I mean, you can take it either way. The defense can obviously say that it's just for her relationship with her boyfriend, and the Commonwealth says no, it means her relationship but it's not clear. And in that kind of situation, when the evidence is so inflammatory, that should lean towards the defense as opposed to the prosecution. So I think it's equivocal, and I don't think it necessarily states that at all.
Counselor, at the first trial, the victim didn't say anything about this being about her relationship with her boyfriend. And of course, nobody told the judge at the motion in limine that she was going to say that, I guess because nobody expected her to say that. So when nobody knows that, and the judge rules on the thought that it is about her relationship with the defendant, and it's already been discussed in opening statement and been described, is the standard different when it's a motion to strike based on this new information? Does the judge have more discretion to say, well, it's already in, that doesn't make sense to strike it now?
No, I think the judge should have jumped in because of the nature of the document. It's so inflammatory. It's not, and the fact that because it's so, that's why the Commonwealth kept going back to it. So when it comes into evidence, the Commonwealth describes how it came into, how she received the text. It was in class, an AP class, and he goes into great detail about that. And then he exploits it in closing argument. He tells them to look at the document, find out the relationship. But she specifically said it didn't involve her relationship with him. And at that point, it should have been stricken because it is.
Can I stop? Can I ask you a question on the? Let's just do a relevance first before we go to whether it's outweighed by prejudice. In terms of relevance, even if she on the stand denies that it was for her and him, can't the jury infer from the fact that she asked for it, he gave it to her, he's 20 years older than her, that it is about them, even though she denies it?
I don't think the jury should be allowed to have the evidence to make that inference. I think that Mr. Enriquez specifically said it was for him and the mother, and it was for them. In fact, he testified that the complainant had bothered him for it, and he eventually succumbed and gave her the document. So I don't think that jury should be allowed to have this evidence before it, because it does substantially sway how they look at the defendant. I mean, and especially since it happens so late in the game. The inference is that he's a predatory person who's going after a young girl, and this was after she was 16, this document came in. And the judge even says that he acknowledges that the document came in late in the relationship after she was 16. So there's no way that the jury cannot be swayed by something that's so deviant, so kinky that it just attracts attention. And the Commonwealth actually gravitates to it because of that.
Counselor, could you walk me through, if it was excluded, how the defendant would have handled the fact that this letter is his explanation for why he apologized, that he thought that that's what it was about, and that his prior testimony and his statement to the police is all about this statement? How could that be handled if it's not in?
I'm not sure I understand the question, but I think that when he was confronted with something, it was apparently the mother came across an image on her iPad and was, called the police and whatnot. And he thought it was about the email, and the email, because according to his testimony, was between him and the wife. That he was obviously apologizing for the fact that he shared that with her daughter. So, I mean, I don't think that, I'm not quite sure I'm answering your question.
I guess what I'm trying to understand is if he's going to say, well, I apologize because I shared something sexually explicit with the daughter, how much worse is that? How much better is that than seeing this document?
I'm still confused by the question, Your Honor.
All right, well, so if the document isn't in, how does he explain why he apologized to the mother?
Oh, you're saying because if it doesn't come in, why would he apologize? Is that the idea?
Well, presumably he doesn't want anyone to think he's apologizing for raping her.
Right.
So,
well, I mean, I think it can say it's in reference to a sexually explicit email to that level, but the specifics are so inflammatory that you can't get by that. I mean, there's no way you can look at him differently once you hear that, oh, he wanted a deviant, dominant, submissive relationship, and oh, this is the type of thing she was looking for. She specifically says that wasn't for me. So I don't think it should ever have touched the jury, and the defense counsel made every effort to keep it away from the jury, and the judge insisted that it come in, and it tainted the trial.
Can I ask, at the first trial, he was convicted of a dissemination of harmful materials, right?
Correct.
Did the jury at the second trial have evidence that he disseminated harmful materials to her?
No, I don't think so. I may be an error, but I don't remember that at all. No. So this particular document is the thing that would cause a response, as opposed to just the bare facts on it. And there was enough in this case for the Commonwealth to present a case without it. And it can't be fairly said that it's the Commonwealth demonstrated that the jury could carry out its truth-seeking function without it. I mean, it was a bad act of evidence, and it should not have come in.
So where the victim testified that she asked the defendant to send her the rules because she said she wanted someone to pay attention to her, take care of her in a kind of way, and actually care about what I was doing and what was going on with me, because I didn't feel like my parents did at the time, although I know now they did. Why can the jury not infer that these rules were in fact for the defendant and the victim, and perhaps she was embarrassed to say that?
I think the jury will infer, it's in front of the jury, they can infer whatever they want. It's our contention that it should never have come before the jury, because they can't get by the inflammatory nature. And so obviously the jury's just going to listen to the evidence and balance it. But if you balance the way this evidence, what the evidence is, it is so prejudicial, it is so inflammatory that you can't get by it. You can't get by, it has all the earmarks of predatory, and it's after she turned 16. So its relevance, it doesn't go to, because Mr. Enriquez is saying the only sex happened after she was 16, and obviously she says differently. and it's not relevant to that. It's nothing more than inflammatory. I mean,
Well, when you say it's not relevant to that, I mean, the Commonwealth, basically, their response to that is that the question is not just simply a matter of whether she and the defendant first had sexual intercourse after she was 16, but the whole nature of their relationship, and that it was started as statutory rape and continued from there, and that this document tends to prove that.
I think it may be relevant towards that, but it's not probative enough to not be prejudicial. I mean, there's certain relevant. It doesn't matter if it's relevant or not. It's a matter whether it's more prejudicial than probative. I don't think without that document they had a case, but with the document they had a tainted case. They had a case that painted the Mr. Enriquez in such a way that changed the view of the jury to it. And it substantially swayed. That judgment had to be substantially swayed by that error, because you can't get by it. It's deviant. It gives a whole different flavor to the relationship than one that was described otherwise. And obviously, the Commonwealth gravitated towards it because it is that, and that's why they misstated.
The fact that he even gave it to her shows that their relationship was not what it should be.
Well, I think the testimony might do that without it. The whole point is that they still had a case without it. They had a substantially weaker case, and it's our contention that with it they had a tainted case, and with that tainted case, it managed to push it over the edge. Instead of just a credibility thing, it's something that's exciting, and it's got all the earmarks of something that would your mind goes to. It's like, oh wow, it's dominant, submissive, and it's used continually through the trial just for that purpose, just to inflame the passions, and that's not right. And because of that, he didn't get a fair trial. So we believe that Mr. Enriquez's convictions should be reversed, and the case sent back to the Superior Court for a new trial, because the judgment was substantially swayed by this error. And if there's no other questions, I'll rest on my brief.
Seeing none, thank you.
Thank you.
We'll hear from the Commonwealth.
Can you hear me now?
Yes.
Good. Good morning, Stephen Greenbaum for the Commonwealth. It appears the court understands the Commonwealth's position. Our bottom line is just, you can read the list and read the content in that. And yes, it's disquieting. It's perhaps bizarre to many people, but the whole nature of the relationship that the victim testified to is also in the same nature, disquieting and be disturbing to a jury as well. And so that the inflammatory aspect of what was contained in the list is inherent in its relevance, and that's just part of the case. It's not unduly and unfairly inflammatory. It just happens to be the nature of this evidence, which did reflect the nature of the relationship. And it was evidence that she was aware of these rules prior to before him sending them. She was aware of the nature of this relationship before then. But other than that, I would rest on my brief and attempt to answer your question.
So counsel, the theme of today, and was the theme of the case earlier, seems to be, was a proper foundation laid here. And here we have, if anything, she's saying this was more for mine and my current boyfriend, right? And you're sort of, so you don't have her saying affirmatively, this was some for me and the defendant, or for us, for the defendant and me. So you don't ask the next question. Why, particularly with a document this inflammatory, why is that sufficient foundation?
For relevance, you're saying, not for authenticity or anything, it's for relevance?
Yeah.
All right, that response, more for mine was, whose relationship was this supposed to define? She wanted the printed list more to define her relationship with her current boyfriend. Fine. The fact is, she's aware of these rules. I understand your question, but I'm not sure that it needs any more to be defined. She's saying, I need this list I want to show it to my boyfriend. We don't know why. Did she want that same relationship with him? Did she want him to understand her relationship with the defendant? Even if she said, well, it really wasn't about the nature, that wasn't the relationship I had with the defendant. The fact that she's aware of these rules and the defendant has them and she wants them for someone else still sheds light on the nature of the intimacy of her relationship with the defendant and what was going on, and tends to confirm her statement that this wasn't the one-off aggressive seduction that the defendant testified to, and that he didn't want to have sex with her anymore. That's his version. Is she came on to me, she virtually attacked me, and we never had sex again. Her story is much more like a grooming relationship, something much more similar to something someone who would have a list like this might be prone to. And given that relevance, her answer, more for my boyfriend, it might be ambiguous, but it certainly isn't a specific denial that it wasn't about our relationship, my relationship with the defendant. It was like, it's more. I really don't see it being as ambiguous. It's more for the boyfriend. Well, if it's more for the boyfriend, then it had to have some relevance in some context to the relationship with the defendant. That would be our position.
Is it undisputed that the email was sent after she was age 16?
Yes. It was sent to her in the fall of 2016. She turned 16 in May of 2016. It was sent to her at school, or she received it in school in the fall of 2016.
Assuming she had testified that the email was just for her and her boyfriend, it's sounding like you're saying it should still be admissible, but why don't you tell me, would you contend it was still admissible?
Well, I hate to off the cuff try to answer that question when I hadn't considered you asking it, and give an answer I'll regret later on. But I'm sure that I would feel comfortable in saying that even if she had given that answer, that the content of that would be relevant. Well, I'm not sure. I believe the judge could have found it relevant based upon the fact that she was aware that the rules existed. She was aware of these rules, and as you noted from her testimony, like she wanted some rules, someone to pay attention to her and take care of her because her parents weren't paying attention to her at the time of 16. And this is at a time when, according to her, she's still engaged in this year plus long relationship with the defendant, as well as this new relationship with the boyfriend.
Do we have evidence of the age of the boyfriend?
I think it said, there's mention somewhere in there, there's mention of something about an age of 18, but I can't tell you what this, I don't recall. I just remember reading that somewhere, that someone says the boyfriend is 18.
Do you agree the evidence of the dissemination of harmful materials didn't come into the second trial?
No, in fact, I think that was the subject of a motion in limine, and the court ruled and the Commonwealth agreed that none of that would come in. So as far as I know, it did not come in at all.
Thanks.
Was that also after she was 16?
I don't recall. I think it may have been. I don't want to say yes because I don't know for sure. I would want to point out two small things to point out. Number one is, despite the supposed excessive manipulation of this evidence by the Commonwealth, if you look at the transcript, which is I think like two and a half full days of trial, however many hundred pages, there's less than 10 pages that talk about the list. Overall, I know the list did come into evidence, was an exhibit there, and in the closing, the defendant suggests that, well, this was used to show he's a bad character. But if you read in full context, he only mentions the list, the prosecutor is closing in one paragraph specific to address the defendant's claims. Oh, I'm a very timid man. I'm sexually timorous. Oh, my goodness. And it was part of a whole theme of his closing that the defendant's testimony was just improbable and inconsistent, not the defendant as this horrible monster, as you can see from this list. So I think that's an unfair characterization of how the prosecution employed that. And for what it's worth, the list came in the first trial and the jury wasn't so substantially swayed that they convicted him on these charges in the first trial. So how inflammatory could it have been if the first time through it didn't sway this jury? I know that's not particularly relevant to your consideration, but it is one factor to keep in mind. If there are any other questions, if another, then.
Yeah, okay. I don't see any. So thank you both for your presentations. Again, interesting case, and we'll take it under advisement.
You're welcome.
We are live and on the record.
Thank you. Good morning, Council, and welcome to the Massachusetts Appeals Court oral argument session for March 12, 2021. As you know, this argument is being held on Zoom and being live streamed on the Appeals Court's YouTube channel. The panel for today is Justice Vicki Henry, Justice Joseph Ditkoff, and myself, Greg Massing. We will follow the same rules and customs as if we were in the physical courtroom, except you're allowed to remain seated if you prefer. Once we get going, the session clerk will display the countdown clock, which will show 15 minutes for each side. In the Appeals Court, there's no rebuttal. You're welcome to use all your time, but there's no penalty if you finish early. Only one advocate will speak at a time. The others will be muted. However, we ask you to stay on the screen so we can know you're still here. And at the same time, though, to keep your reactions to a minimum because that can be distracting. Before we begin, we all noted in reading the briefs that the Commonwealth's brief was signed by ADA Kevin Curtin about 10 days before he suddenly and unfortunately died. And it might well be the last brief that he signed. We're not quite sure. The entire court and the entire bar mourns his passing. He was one of the most prolific appellate attorneys to appear before us, and well respected and well loved, both as an attorney and as a person. That said, we'll decide the case on the merits with no bias or for that matter, but had to comment on that. As always, we've read your briefs and we're familiar with the case. In fact, we have your briefs and record materials open before us on our computers and tablets. So if you see us looking away from the screen, it's not that we're not paying attention to you, but rather we're looking at the case materials. So with that, I'll call the case, which is Commonwealth versus Christian Lopez, 2020 P 834. And I have to give me, I'm sorry here, I'm in a little technical difficulty myself. There we go. Attorney Weber for the defendant.
Thank you. Philip Weber representing Mr. Christian Lopez. Mr. Lopez's case is here today because there was an illegal search performed on him, which had multiple problems. I'll begin with the exit order not being justified as there were no safety concerns. The police observed Mr. Lopez looking down into his lap while he was driving, speeding up and slowing down. Now, it was quite clear that this activity was just being a distracted driver, using his cell phone while driving. Maybe not a good idea, but certainly not something that makes him a danger to police. And this is not wild speculation. This is police officer testified at the suppression hearing that it appeared as though Mr. Lopez was using his cell phone. So that's the police observation as well. So that action certainly has no bearing on any kind of danger. While pulling him over, the police observed Mr. Lopez bending forward at the waist, seemingly reaching towards the floor of his vehicle. Now, considering that he had just been caught using his cell phone while driving, it makes perfect sense that as he's being pulled over, he doesn't want to have his cell phone in his hand, that he'd be reaching to the floor. It's a very logical thing to see there. But even if that is not known with definitiveness, a simple action of simply reaching towards the floor, some minor action like that, is not a justification for a safety search. It's
So counsel, what you say is logical, but do we have to, or does, I should say, a police officer have to just assume, take an assumption, a risk with their life that that's what's happening versus if they have a concern for their safety, check it?
well, there's numerous case law that does talk about that some minor movement is certainly not enough to justify police safety concerns. So this action by itself would clearly, without question, not be enough for a safety concern, even when combined with the other actions, which I will be addressing, which are all very minor enough in themselves. I believe it is problematic to assume that any small movement by an individual is a safety concern. That is how we, unfortunately, lead to circumstances where minority individuals, such as Mr. Lopez, end up getting shot in common traffic citations, that police are assuming that any minor movement suddenly equals a huge safety concern. And while I certainly respect police officers' need to protect themselves, there's also the need to protect the lives of an individual being pulled over for something as simple as a traffic citation. And I think that needs to be weighed as well.
Why do you think he'd be more likely to get shot if the police can order him out of the car versus if the police can't order him out of the car and just have to hope that he wasn't reaching for a gun on the floor?
Well, a lot of this comes to this mindset that he's suddenly a dangerous individual just because he made any minor movement. It automatically leads us to a place where these common traffic citations suddenly become escalated to the point where really it is just a minor traffic. This really did all start as a traffic citation, nothing more. There was no other reason to stop him. So it's already escalating the situation, ordering him out of the car, escalating a situation that doesn't require that level of escalation. I'm not saying that the police should turn their back on him and let him do whatever they want. Obviously, they're still going to be observing him. In this situation, there were multiple police officers. Mr. Lopez was by himself. They certainly had the ability to keep observing him at all times. And as stated, there's numerous case law that does show that just because there is some minor movement, it's not enough to order him out of the car. It's not enough to just presume just because of a minor movement.
What's your, you keep saying it was minor, but he's reaching down to the floor. So what's your best case that this was in fact a minor movement that did not justify the exit order?
I apologize that I don't have the case right offhand, but I do cite to cases within the brief, and I apologize for not having one right now to be able to say to you, but I do cite to cases talking about minor movements not being enough simply, and I apologize, don't have them, but they are cited to within my brief in regards to the movement not being enough just by itself to justify the safety concerns. And
I want to ask just a clarifying question. You're arguing that the exit order was not justified by reasonable suspicion of a threat to safety. I do not see any argument that the pat frisk, once he was out of the car, I don't see any argument that the pat frisk was improper. Is that correct?
That is correct. If the exit order was unjustified, that would address everything else. But if there was a safety concern, the pat frisk of his outer clothing, that would have been a justified action. That is correct, Your Honor.
Okay.
Indeed, and beyond just the in fact, in addressing that, because the pat frisk of the outer clothing would have been justified, but the police still would have exceeded the scope of any type of safety search in the search of Mr. Lopez's shoe, because
before they search his shoe, they tell him to sit down on the sidewalk, and you're not arguing that it was wrong to tell him to sit down on the sidewalk either, right?
Well, that falls into the lack of a justification for the exit order. But again, if we were to assume arguendo that the exit order was justified, then sitting down on the sidewalk would have been justified. That part of Your Honor, yes.
Okay.
So, and again, to say it all depends on, because the exit order obviously is a very significant element, because if that is not justified, then nothing beyond that. But if that were justified, then pat frisk of the outer clothing, sitting down on the sidewalk, those would have been justified activities. It really was the search of a shoe that reached where they exceeded the scope.
No, if the defendant consented, I know you raised this issue as well, but if we were to uphold the judge's finding that he consented to the search of the shoe, then doesn't that dispose of your argument that it was beyond the scope?
That is correct, Your Honor. And thus why I do address the consent issue, because I think it is clear that he did not consent, or if not clear, it is at least ambiguous, and that ambiguity would favor the defendant, because as Your Honors are aware, with all warrantless searches, the Commonwealth bears the burden of proof that consent is freely and voluntarily given, citing to Crisco, and they have to establish that the individual's words or conducts amounted to something more than simply just an acquiescence to the claim of authority, just a resignation to the power of the officers. Now, in this case, there were no actual words. Mr. Lopez never said, "I consent." He never said, "Go ahead and search me." There are no words of any kind. It's an action. That is the basis of this supposed consent, this action of him kicking off his shoes. Now, this action.
Well, if we change the facts just a little bit and assume that the police officer just says, "Do you have a weapon in your shoes?" and the person kicks off their shoes, would that be consent to search the shoes?
No, I don't. No, I do not believe it would be that. I don't believe that would be consent either. I mean, it is of course important that, as Your Honor says, if we change the fact pattern. So obviously I'm addressing the fact pattern in this specific case. Even then, I don't think it would be enough for consent, however, because even in that situation, if that is the one thing that was changed, what the officer said, it still is an acquiescence to the authority. Because in this situation, we look to many things to consider whether or not there was consent, whether or not there was the presence of armed officers, which there was here, whether the defendant was informed of his right to refuse consent. He was not. The age, Mr. Lopez is a young man. Any other personal characteristics. In this case, Mr. Lopez's English is extremely limited. It is not his first language. So there's going to be, he had enough English to have basic communication, but still limited. So it's still something to consider amongst the many other factors. And I think it's important as well.
Is there evidence of his abilities, his English ability in the motion to suppress?
I believe that it is referenced to, and I believe there was indeed even an interpreter at hearings, but even without the language issues, there's still enough factors to show that there was not consent, even if you took away language altogether. The police officer asked Mr. Lopez about his foot. He didn't say, can I search your foot? But he did ask, because Mr. Lopez was walking in a somewhat odd manner, asked him, what's going on with your foot? Mr. Lopez responded, nothing, it's fine. Police officer asked again. Now, the first time he was asked about his foot, he didn't just immediately kick off his shoe. He didn't immediately say, go ahead and search it. He says, nothing. Police officer asks again. For a normal person in that scenario, it seems like the police are saying, we're going to be looking at your shoe, especially when you consider what's already happened up until this moment. Mr. Lopez was pulled over without being asked if he consented to it. He was ordered out of the car without being asked if he consented to it. He was pat frisked without being asked if he consented to it. They searched his car without being asked if he consented to it. Why would he suddenly believe that he had the right to refuse consent on the search of his shoe? Considering everything that's happened up until this point, why would he suddenly think this is the place where I'm allowed to draw the line? Even here today, we are arguing a case in which the Commonwealth argues that he didn't have the right to actually refuse to consent. The Commonwealth is arguing that the search of his shoe was part of the safety search. So their argument is that he isn't allowed to say no. So if it's
that all assumes that the officer, either directly or in effect, instructed him to take off his shoes and let him look through it. And I understand there's evidence at the suppression hearing where a judge could have found that. But why did a judge have to find that? Why is it clear error for the judge implicitly to find that the officer never implicitly or explicitly instructed him to take off his shoes?
Well, there's no other reason for Mr. Lopez. I mean, common sense would dictate that there's no other reason for Mr. Lopez to take off a shoe unless he did, in fact, think the police were going to search a shoe.
No, there's another reason, which is that because he was consenting to a search of a shoe, which is what the judge found. I mean, so that's at least possible. It's not the only thing you could conclude from here, but why could a judge not conclude that?
Well, I believe that because considering the circumstances, if you're looking at it from the way Mr. Lopez is looking at it, the police have they're already searching him. By the time the shoe comes off, they've already taken him out of the car. They've pat frisked him. They searched his car. They've searched his car. They've searched his outer clothing, and they're asking him about his shoe. I understand what you're saying, that there are possibly other ways to interpret it, but I think that is an extreme stretch to the point of being an abuse of discretion to think that Mr. Lopez would suddenly kick off his shoe, even if he didn't think they were going to search him. I mean, for him to.
Oh, but why is, just because someone thinks the police are going to get a search warrant doesn't mean that they can't consent to a search of a house. The motive for the free and voluntary consent to the search doesn't have to be, I just want these police officers to see what's in my house. That doesn't have to be the case. You can have different reasons to want to consent. So, what do you have besides the fact that, he thought they were going to search anyhow? Or do you have some argument that the fact that you think they're going to search anyhow means you can't consent?
Well, Mr. Lopez himself actually testified at the suppression hearing, and he testified that he only removed his shoe because he believed the police officer was telling him that he had to do so. And I understand that normally one might be skeptical of.
Didn't he testify that the police actually told him to remove his shoe?
That seemed to be part of his understanding as well, that he thought that he was being ordered to, that it was in fact being ordered to remove his shoe. That was Mr. Lopez's understanding of the situation. And I think it's important that while I understand that in some circumstances, one might be skeptical of the veracity of the defendant, thinking that they might testify in their own self-interest, I think it's also important to note that in that same suppression hearing, Mr. Lopez actually testified that he was returning from buying drugs that day. That's what he was doing at that moment. So he's certainly not testifying in a manner that's going to be overly beneficial to him. He's on the stand essentially admitting to possession of drugs while talking about what happened. So
Are you arguing that the judge clearly erred in not believing his testimony?
Well, I think his testimony was one part of it. It is not the be all end all. It's not the only thing in here, but I think it is significant that Mr. Lopez's testimony is something to be considered. And I think it is certainly an important factor because, as stated, he testified very frankly, very openly, to the point where it would harm him. When an individual testifies in a manner that harms their own position, I think that shows that they're not trying simply to save their own skin. They're not just trying to testify in a way that's beneficial. They are telling the truth, even when it is harmful, which in this case, at least that part of the testimony is not helpful to him. Ultimately, I think that it's hard to think that Mr. Lopez had thought he had any right to refuse consent, considering everything that had happened. And the case law does show that the Commonwealth has to provide us with more than an ambiguous set of facts that leave us guessing about the meaning of the interaction. And I think this interaction, at best, leaves us guessing about the meaning. At best, it is ambiguous and certainly not clear whether or not he would consent. So considering that factor, I think that we would have to show that there was indeed no consent. And while I have multiple other issues obviously addressed, I see that my time is just about run out, and I don't think 12 seconds is enough to really address them. So unless any of your honors have questions, I would rest on the brief.
Seeing none, thank you very much.
Thank you.
And we'll hear from the Commonwealth.
Good morning, Your Honors. May it please the court. My name is Jake Goldberg. I'm a law student at Boston College Law School, and I'm appearing for the Middlesex District Attorney's Office on behalf of the Commonwealth. With me today is Assistant District Attorney Krista Elliott. And for three reasons, this court should affirm the judgments of the Superior Court. Those three reasons being, first, the exit order was justified by the officer's objectively reasonable safety concerns. Second, the officer's extended pat frisk of the defendant's shoe was also justified. And additionally, the defendant did in fact consent to the officer looking inside the shoe in the manner in which the officer did. With regards to this first point, Your Honors, the defendant argued that, the defendant argued that the officer did not possess valid safety concerns and was therefore not justified in ordering the defendant to exit his vehicle. But the legal standards that the defense counsel puts forward in their brief aren't exactly how this case should be reviewed. Specifically, this court should review this particular aspect of the case with regards to the standards set forth in the case Commonwealth v. Amato. This was the standard that the motion judge used and is the standard that should be used again upon review. That specific standard states that an officer may order a passenger of a validly stopped vehicle to exit that vehicle if a reasonably prudent man in the policeman's position would be warranted in the belief that the safety of the police or that of others was in danger. That standard is certainly met here with regards to the facts of this case. Additionally, I would like to point out that while defense counsel pointed out both in his argument right now and as well in his brief that there were actions when viewed in isolation may be considered innocuous, that again is not the standard that this court should be reviewing in reviewing this entire encounter between the officer and the defendant. Again, the case Commonwealth v. Amato speaks to this exact issue, and it states that evaluating such a reasonable concern for safety requires a court to examine facts as they reasonably and objectively appeared in the context of the ongoing encounter, not in the context of what each specific act may look like by itself. And from the beginning of this,
what are the specific factors then that justified the exit order here?
Sure, Your Honor. There are several specific factors, some before the stop even took place and others after the stop took place. With regards to the ones before the stop took place, the officer knew and testified to at the hearing that the area in which this encounter occurred was a high crime area with numerous assaults, shots fired, and drug dealing occurring within that area alone within the last several months of this exact stop. Additionally, the officer noticed the defendant looking down and perhaps manipulating something in his lap. It was never directly testified to by the officer that he saw a cell phone. Specifically, the officer's testimony was that it appeared as if he was manipulating a cell phone. But even more to the point, Your Honors, as this encounter was playing out and before the car was even stopped, the defendant's Board of Probation record was brought up by the officers when they were following the vehicle. And they identified through running the registration of the vehicle that the owner of the vehicle had a lengthy prison sentence on a federal narcotics distribution charge. And that sentence was still being served at a probationary stage. The officer knew from his training,
Why does that make it more likely he's dangerous? If anything, that makes it less likely he'd be having a weapon so as not to lose his.
Well, Your Honor, according to the officer's testimony, the officer testified at the motion to suppress hearing that from his training and experience, it was his experience that suggested to him that individuals involved in the narcotics trade often keep weapons on their person. To your point, though, Your Honor, that was not the only factor here that justified the officer's reasonable suspicions of safety concerns for himself and others. Even after the vehicle was stopped and before the exit order was issued, the defendant was seen bending forward at his waist with his arms and shoulders reaching down towards the floor of the vehicle. This was not an action that took—
Mr. Goldberg, though, the Commonwealth does bear the burden of proof to justify the search, and there doesn't seem to be testimony about the phone. So if the officer thought he was manipulating a phone, which is what many people are doing if you just stand and look at traffic, a shocking number, and then you don't put any evidence about whether there's a phone in his lap or whether there's a phone somewhere on the front seat. So, you know, there's just an absence where the Commonwealth doesn't ask the question it should have asked. So what do we make of that?
Well, as you pointed out, Your Honor, that wasn't sort of a line of reasoning developed at the actual motion to suppress hearing. That is an absent fact in this particular case. But even absent that particular line of questioning and testimony offered, there is still sufficient facts to reach the standard of OMAR that I had laid out earlier. Reaching down to the floor of the vehicle was just one factor, again, that the officer observed. In addition to that, there was a general nervousness of the defendant on this cold November night due to his sweating. And the officer did testify, and it was not contradicted, that there was no heat blasting or emanating from the vehicle of the defendant. And even more to the point with regards to reaching down to the floor, Your Honor, the defendant was evasive when asked by the officer if what he had been reaching for. He stated nothing. So given this totality of this ongoing encounter, just to this point, the officer, given his training, his knowledge of the area, the observations he had made about the defendant, and the defendant's own evasiveness, the standard certainly was met here to have an exit order be issued in a valid manner. The cases that are cited in the Commonwealth's brief regarding Commonwealth v. Stampley, for example, is an analogous case. Additionally, with regards to
which argument do you think is stronger for the Commonwealth, that the defendant consented to this search or that there was an objective, reasonable fear for officer safety?
Your Honor, it is the Commonwealth's position that the defendant consented to the search.
I know, but I'm asking which argument you think is the stronger argument for the Commonwealth.
The argument that the defendant consented to the search certainly is, Your Honor. But even absent that, as the motion judge also pointed out in a footnote to his order, even if that wasn't an issue here, the voluntariness of the consent being offered, there is still objective reasonableness for the officer to have searched that shoe. And
so Attorney Weber makes certainly a compelling point that why would this gentleman believe that he had the ability to consent to a search when he was ordered out of his car, he was pat-frisked without his consent, and he was told to sit on a curb, and he was giving answers that the officer was not accepting. So why would he even think that he could say no?
That's a great question, Your Honor. And what I would submit to you is that the standard of analysis here seems to be, again, slightly off. It's not for the court to say what was in the mind of the defendant, whether he thought he could consent or not. And I would point Your Honor's direction towards the Gaynor case that speaks to scope of consent, as well as the Rogers case cited in the Commonwealth's brief that speaks to how implied consent can be provided. Absent unfettered coercion on the part of the officers here, consent can be provided in either an express or an implied way. So it does not need to be a situation in which the officers are directly asking and the suspect, in this case the defendant, is directly stating, yes, I will let you search my shoe. This was not just a case either in which the defendant simply took off his shoes. The defendant took off his shoes as a physical act of responding to the officer's question after providing a verbal act of response to the officer's question of, is there something in your shoe? He says no, and he simultaneously kicks off both of his shoes. that certainly meets that Rogers standard of whether or not implied consent was present. And to the point that defense counsel raises, which is valid, the Commonwealth does bear the burden of showing that that action was not just mere acquiescence to a claim of authority, but there was no claim of authority being issued by the officer. The officer certainly was not stating, you need to take off your shoes. The officer is simply posing a question in a calm manner, and both parties testified to the calmness of the conversation here. There was no yelling, no shouting. Both parties testified to that in the motion to suppress hearing.
After removing the defendant from his car without his consent, and after putting his hands on the defendant's body without his consent, and after ordering the defendant to sit on the curb without his consent, where's the ability to say no?
He did not need to take off his shoes, Your Honor. He voluntarily did that. In fact, if we're going to look at the testimony the defendant offers, when asked during direct examination, when he takes the stand, the defendant does answer in the affirmative, yes, I voluntarily took off the shoes myself. That was not something that was ordered by the
Didn't he
officer.
also testify that the officer ordered him to take off his shoes?
Well, this speaks to the broader point, Your Honor, that the motion judge ultimately didn't credit these statements that both I just stated and also that the defense counsel had raised. These were not considered credible statements of testimony offered by the defendant when he took the stand. I was simply pointing out the fact that in response to your earlier question, Your Honor, the defendant did not need to take off his shoes. So he voluntarily engaged in this action in response to a question posed to him. Again, a question that was commonly posed and a question that was a part of the ongoing encounter that built to the reasonable suspicion of the officer. To your point, Your Honor, there are two ways in which this can be seen as a justified action on behalf of the officer. It is the Commonwealth's position, and it is my view that the strongest argument is that consent was provided on an implied basis, and that the scope of that consent was not exceeded. However, even if that were not found, just as the motion judge says in this case, the officer did maintain reasonable suspicion of danger. And I would point Your Honors to the standard articulated in Commonwealth v. Torres-Pagan. That was not a case that we cited directly in our brief. However, that is a case in which the court sort of adds a little more nuance to what the standard for a valid pat frisk is. In that case, the court sort of added this nuance by stating that police must have a reasonable suspicion based on specific articulable facts that the suspect is armed and dangerous. And that's precisely what was going on in this particular fact pattern, Your Honor. Again, all of the facts that we have spoken to date support that legal standard. The actions that the...
So they order him out of the car, they pat frisk him, he's got no weapon, he's got a license, the car is registered to him, even though they checked that themselves. He's got $300 on his person. What is there a fear at that point that he's armed and dangerous?
The fear that he is armed and dangerous, Your Honor, is the continued evasiveness and awkward movements of the defendant. So even when initially when being stopped, the defendant is seen sort of reaching from his upper body down towards his lower body. And it is not within the officer's line of vision to see precisely what the defendant is doing at that time. When asked to exit the vehicle, which as we had stated was a valid exit order, the defendant is then seen with both of his shoes untied, after again leaning down towards his shoes and not being able to see precisely what was going on while leaning down. Not only was he caught with no shoes tied, he was also seen awkwardly favoring one leg, particularly putting his weight on his left leg and not his right foot. In addition to that, when asked, after having been evasive, when asked what he was...
He wasn't wearing boots, right? He wasn't wearing those boots that you meant that's cited in one of the cases. Can he reasonably have a gun or a knife in his shoe?
From the officer's perspective, yes. The officer, in fact, testified that he had seen knives hidden in suspects' shoes in the exact manner in which people were awkwardly walking like this. So again, given the perspective of the officer, given his training, his experience, and the things that he had seen in the course of his conduct in prior engagements, this was a reasonable belief that he maintained from the start to the finish of this encounter.
What about though, so the officer picks up the shoe and shines his light in the shoe, and I believe the evidence was that it was a sneaker,
Right.
and he can't see a weapon at that point. Why is further search reasonable?
Further search was reasonable, Your Honor, because simply shining your shoe through the small insert at the back of the shoe doesn't reveal the actual contents of the shoe. The officer was only required to do what was minimally necessary to determine whether or not a weapon was potentially being possessed within that shoe. Certainly shining the light was one step towards revealing if anything was immediately in it. The tapping of the shoe was the necessary next step to see what was in the portions that was not able to be visibly seen by just shining your light within the shoe.
Did
And
the
I would also
officer
point out
testify that he could not see the entire inside of the shoe?
that was not
'Cause again,
directly
we're not talking about a boot and it's the Commonwealth's burden of proof.
correct, Your Honor. The officer didn't directly testify to not seeing everything in the shoe, but what was said was that there was no, and this was credited by the motion judge in his findings of fact, there was no observations that were made from just looking directly into the shoe alone. And so again, in order to alleviate that reasonable suspicion of fear, particularly that the defendant was armed and if so dangerous, there needed to be a full search of that shoe. And I would add that the police officer did not exceed any sort of reasonable scope that was provided after the defendant had kicked off his shoe. This was not an instance in which the officer was putting
But
his hand
again,
within.
there's no picture of the shoe. The shoe wasn't in evidence, right? We don't know nothing about like the cut of the shoe or how hard it was to see into the shoe.
In terms of the findings of fact made by the motion judge, Your Honor, that's correct. But again, the motion judge did credit the police officer's testimony when he said that he could not make a full observation no observations were made with the direct wording by the motion judge in his findings of fact. Just
What
by
page
shining.
of that is that in the record?
I can try and pull up the exact page, Your Honor. I apologize, I don't have it directly on hand. It was in fact near the end of the motion judge's findings of fact because it was brought up by both parties when he was amending the motion judge's the findings of fact. But the direct line, I believe, was no observations were made after shining his light on the shoe. But even still, Your Honors, what I would put forward to you is that with regards to the consent and with regards to the appropriate scope of consent being acted within by the officer did not exceed what was minimally necessary. To just simply look into the shoe would not reveal its full contents. And this was not an instance in which the officer dug into the shoe with his hand. It was not an instance in which the officer was shaking the shoe. He simply tapped it to reveal what was ever at the top of the shoe that was not able to be seen just by looking within it. Your Honors, I notice my time is coming close to an end, but I'd be happy to answer any further questions if you would feel that's best.
Seeing none, want to thank you both for your arguments. Excellent arguments on both sides, and especially impressive for a law student, Mr. Goldberg. So good luck to you in your career. We'll take the case under advisement. For those of you who are watching who might be in the 4th, 5th, and 6th cases, our plan, if possible, is to go as soon as possible to the next case, if everybody's available. And then we'll take a break after that. So if you're in the 5th and 6th case, we're going to have another case and a break no matter what. But hopefully for the 4th case, we'll be getting to that right away. So thank you all, and have a good afternoon, good weekend.
Thank you, Your Honor.
Thank you.
Greg,
It gets 15 minutes, although I understand that the department and the child or children are dividing their time, 10 for the department and 5 for the children. You're welcome to use all your time, but there's no penalty if you finish early. And when you're not speaking, you'll be muted, but we can still see you, and we want to be able to see you to make sure you're here. But at the same time, because we can see you, please keep your reactions to a minimum because that can be distracting. This case is impounded, so please let's not refer to the mother or the children by name. Use descriptions like oldest child, the twins, etc. in this case. And as always, we've read your briefs and we're familiar with the case. In fact, we have your briefs and the record on different screens in front of us. So if you see us looking away, it's no disrespect is intended. We're looking at the case materials. So with that, I'll call the case, which is Department of Children and Families versus Mother, 20P791. And Attorney Robin for the mother.
Thank you, Your Honor. Good morning, Your Honors. May it please the court. My name is Valerie Robin, and I represent the appellant, the mother who's had her parental rights terminated as to 3 children. This case started in August 2014 with an emergency removal of mother's 10-year-old, 7-year-old, along with her newborn on the basis of a newborn not gaining weight and missed medical appointments. That was it. Mother did have a case with the department in 2008, which was closed and resulted in an open adoption agreement, whereby mother maintained custody of her two older children, the same two children that are part of this appeal, and had an open adoption agreement for her baby twins, who are not part of this appeal. From a concern about a newborn not gaining weight and missed medical appointments, the juvenile court then terminated mother's parental rights as to 3 children. To put this appeal in context, the emergency removal of mother's 10-year-old, 7-year-old, and newborn in August 2014, because of the newborn not gaining weight and missed medical appointments, we're now talking about an almost 7-year-old, a 14-year-old, and 17-year-old. Their birthdays are July, August, and October, and I've rounded up for clarity. I'd like to talk about the due process and the Rule 60 motion, along with the sufficiency of evidence concerning mother's homelessness, domestic violence, and what the court called concerning behavior. This is a case where DCF and an overburdened juvenile court caused this case to be approached in a piecemeal approach, as I call it. Mother testified for 29 minutes to 166 minutes, 10 days, although there was very little testimony, and mother was there quite a bit. On the first day, DCF continued the case. On the second day, DCF had a discovery issue. On day 3, just 29 minutes, and it goes on. It was a confusing nature in terms of scheduling. It was met with a lot of delays. It was chaotic, and it was constantly changing. The court never had the opportunity to get the full picture of mother because mother never completed her testimony. Now,
So counsel, was there ever any failure of notice to the mother about a court date?
Failure of notice, it's unclear from the record. And I point to several places where contrary, my sister argues that notice was there. For example, counsel for father missed the trial dates 3 different times. Now, my sister suggests it was because counsel had childcare issues, but somehow this is not supportive of a confusing and chaotic nature. I'd simply say we had appointed counsel who was not present there several times, has to suggest some predictability of what was going on.
Counsel for mother was there the entire time, right?
Excuse me?
Counsel for mother was always present.
Counsel for mother was present, yes.
Counselor,
And I mean, there's evidence that there's discussion that she had difficulty sometimes contacting her client, but there's no claim that she didn't try.
There's no claim that she didn't try. But what mother was there throughout this case during pre-trial, and more often than not. This wasn't a case that a client wasn't there, except a client wasn't there on several of the last 3 times. And at that point,
Counselor, April 18th, the first time the mother doesn't show up after she started testifying, her counsel says that she talked to her last night and that she's traumatized from testifying. And the affidavit of counsel says that client was notified telephonically and by first-class mail. And there isn't any affidavit or testimony from the mother to say that she didn't get notice. So with that evidence, how would the judge conclude that she didn't know about the court dates?
Based on the evidence before the court treated this as a Rule 60B motion. At that point, the court was well aware of how often mother was present, was well aware of when mother was there, and was also well aware of, at times, everyone would sit around all day, and then the court would call the case for 2 minutes and it wouldn't go forward. But when the court reviewed the Rule 60 motion, even in its procedural history, it didn't adequately reflect what was going on. And so I did argue that it was under an abuse of discretion, and there's an exception that it's void for failure of a due process. And here, the court didn't hear from mother entirely. And because of that, there was a problem. There was a problem because the court knew the chaotic nature, and the problem manifested itself because then the court struck mother's testimony. And yet the court had an opportunity to hear more from mother when counsel for mother came back with its Rule 60B motion. But once the court struck the testimony, there was a problem here in this case.
What do you mean that the judge had the opportunity to hear in the Rule 60 motion? There was no request by your client or your client's counsel to have her testify at that hearing, was there?
At that hearing, there was no request. Mother was present for that hearing as reflected in the record. And almost paradoxically or almost ironically, one of the reasons the motion was denied was this whole idea that the children would be prejudiced because it would delay their future. Yet when that motion was heard, it took another 2 years before the findings came out.
Why wasn't it your burden or your predecessor's burden to show the due process violation by evidence, affidavits from the mother to show that she didn't get notice or something kept her from testifying?
Arguably, under the Rule 60B motion, hindsight is always a way we could have done it better. The issue was raised as to due process. The record was clear, if not the affidavit, that the record was clear of how often mother was present. And also the evidence was clear to the court and to all the parties. And in the end, and in a moment, I'm going to pivot to the problem with the sufficiency of the evidence. So the court had the opportunity, and if this court wants to look back and say trial counsel perhaps erred and didn't show the due process strong enough, although it was raised by raising the constitutional rights, then that's, I suppose, another argument. But nonetheless, we can't ignore of what was going on in this case.
So counsel, the child's brief argues that it was that mother's failure to cooperate with services, DCF and the court and her counsel caused many of the procedural delays that she complains about. And bearing in mind that we see, regularly see DCF cases, termination of parental rights cases, and we don't see these kinds of delays regularly. What's your response that it was the mother who caused this?
I don't think that's a valid argument in this case.
Do you think she caused any of it?
Any of the delays? Well, for example, my sister points out that she changed counsel multiple times. If you look back at the entire transcript and in this case, you have transcripts from every time that this case started with the inception, because that's how the Boston Juvenile Court does it. They give you everything. So with that said, not once was there a suggestion, oh, hello, Your Honor, I'm new counsel. I need additional time to get up to speed. No, there was the issue.
Wasn't there that discovery problem with the 11 months of notes? New counsel doesn't have the notes, and the DCF says we can get them to you tomorrow, and counsel says, well, I'm going to need a couple of weeks to look at them.
Well, I hear what you're saying, Your Honor. However, the burden was on DCF to produce that file. And the court said, no, I'm not, over 11 months, they haven't produced it. And even if it came the next day, then mother's at a disadvantage for a file that should have been produced by DCF. So to blame mother because DCF failed with its automatic ongoing discovery obligations hardly seems equitable or fair. That wasn't about mother's counsel being a new counsel. I think any trial counsel would say, what do you mean? I'm getting 11 months of dictation, 11 months in this case now, so that would be my response to that. And you have to understand that the sufficiency of the evidence just wasn't there. I mean, when you remove mother from this equation, you had 5 witnesses Let's talk about, you had one social worker who came on for mother in July of 2016, a supervisor who never even signed any of the reports. And by that I mean is in these cases, as your honors know, is there's a lot of the exhibits. In this case, I think it's exhibits 1 through 28, 32, 33, 42. These are the DCF reports that are signed by the ongoing DCF worker and the supervisor. The supervisor who testified hadn't even signed one of them. That's how limited that supervisor's involvement. Then you have 2 witnesses that never had contact with mother other than they observed some of the concerning behavior. And then you had, of course, the adoption worker. So when you look at what started as medical neglect, is you look at suddenly, now this case is talking about mother's homelessness, and the homelessness that they're focusing on is whether or not she lived in a van in 2008. Next, you talk about domestic violence. Again, when you strike mother's testimony, what's left? DCF suggests that custody of Vaughn doesn't apply because mother didn't get custody. Well, that just can't, I just don't think that that's the law. I mean, you're supposed to have detailed findings. You have to, mother's history of domestic violence, where's this coming from? It's not coming from mother. And then what's the nexus of how it impacts the children specifically? So in the end of the day, I mean, when you look at this in terms of a preponderance, in terms of the sufficiency of the evidence, after you struck mother's testimony, is it's just not there. And the court had the opportunity with the Rule 60 to either open it up or to order a new trial and to get the complete picture, and we wouldn't be discussing.
Do you think any of the findings of the judge are unsupported without mother's testimony?
Yes, and I believe I set them forth in my brief, and I'm just looking right now. They're in particular, my memory, and I can't point, but I'm fairly certain my brief points is both the court as well as counsel for children and counsel for DCF, even their briefs continue to rely on mother's testimony. You'll see points where they reference the transcript of when mother testified. But specifically, this idea that mother accepted that she was a victim of domestic violence with her 3 abusers. I don't think that's supported by the record without mother's testimony. I don't think the finding is supported in the record relative to the domestic violence, which is a critical piece in this case in terms of the basis of termination. Again, this case was about medical neglect of a newborn. There was no evidence of medical neglect for the older children. And in fact, that's not the focus of the termination. The focus of the termination is homelessness, domestic violence, and sort of the what I call the concerning behavior, or the court calls it concerning behaviors. And in the end of the day, if you look at each of the findings and you strip away mother's testimony, which means the court never got the other side of mother, the court then nonetheless relies on much of mother's testimony, which can't be the case, which shouldn't be the case, rather. So we're simply asking, I'm going to end unless there's any questions for the court, but we're just simply asking that the finding of mother's unfitness is reversed. In this case is remanded back for a new trial.
Thank you. Seeing no further questions, we'll hear from the department.
Good morning, Your Honors, and may it please the court. Special Assistant Attorney General Tasha Bahal for the Department of Children and Families. In this case, the juvenile court correctly determined that there was no violation of mother's due process rights. She was provided proper notice of each and every trial date and was afforded a meaningful opportunity to be heard. The juvenile court also correctly determined, based on clear and convincing evidence, that mother was unfit to parent 3 of her children and that terminating her parental rights was in the children's best interest.
So counsel, I understand that your specially appointed and don't work for the department, but would you consider this case an outlier in terms of the stopping and the starting of testimony?
Your Honor, I've reviewed a lot of cases, published opinions, and there are several cases, including the NISA case, where this court addressed very similar complaints about trial occurring on non-consecutive days, the court not being able to devote a significant portion of the day to the trial. And in that case, this court said, these are things that are outside of the control of the individual judges, and it's a result of the overburdened juvenile court system. So I do not think this is a unique case in terms of the non-consecutive nature of the trial. I haven't seen any indication that is so.
I'm not asking if it's a unique case, but is it, on the spectrum, would you put this in the more of at the outer edge of the stopping and the starting and the number of trial days?
Well, Your Honor, there's certainly cases, adoption of Dawn, where the SJC said that, a 5-year span between the initial filing of the care and protection and adjudication was not a due process violation. There's another case from this court, Your Honor, adoption of Talicia, where this court—
I understand there are specific cases and it's possible that we could affirm here, but I'm asking if you think this is the norm or if you think this is more unusual.
It's difficult for me to say, Your Honor. Based on the cases I've seen, I don't think it's an outliner. Whether it falls within the range of normal or there were a few additional delays in this case, it's hard for me to say, Your Honor. I don't think it's in the realm outside of case law that has affirmed on similar facts, similar delays, similar non-consecutive dates of trial.
Where the findings did not issue for 2 years, why not allow the mother to finish her testimony?
Well, Your Honor, I think that mother made no offer of proof that had the findings issued sooner, there would have been a different result here. And that has been the standard set back down by this court. At the time she filed her motion for a new trial, at the time she filed a motion for the speedy issuance of findings, there was no offer at any time that she had taken any action to improve her parenting abilities during that time. There's no indication that she's, for instance, obtained stable housing. There's no indication, Your Honor, that she has since taken a parenting class or done anything that the department had recommended as part of her service plan to make the department feel comfortable that the children could be safe in an environment with the mother. So where there's no indication that an earlier issuance of finding would have changed the result, I don't believe a remand would solve the mother's concern in that regard.
How do you respond to Attorney Robbins' argument that if you take away mother's testimony, there's not a lot of evidence here? And I know, in your brief, you rely not so much on factual findings, but on the exhibits, many of which are 51A reports.
Well, Your Honor, we try to rely on the 51B reports, as I understand the 51As are meant to set the stage. I disagree with Mother that there are insufficient findings taken away Mother's testimony. There were 5 witnesses. One was the ongoing social worker with Mother, who was able to testify to several of the findings regarding unfitness, including her inability to comply with the service plan, which Mother does not contest on this appeal. That social worker also testified as to Mother's unstable housing conditions and how Mother had not provided a consistent address, but had bounced between friends' houses, various shelters, where she could not get a placement because she didn't want to abide by the curfews of those shelters. That witness was able to testify to a number of the factors that the court relied upon in its factual findings. There was also testimony from additional witnesses who was able to testify as to Mother's concerning an erratic behavior. There was testimony from witnesses who were in the courthouse on the first day of trial when Mother tried to leap over the 4th floor balcony. There was testimony from supervisors at the department when Mother threatened to bomb the department in April 2016. There was testimony from another employee of the department when Mother threatened to bring a gun to the department, which caused a 20-minute lockdown and which caused people in the building to worry for their safety, and the police had to be called. There was significant testimony concerning Mother's behavior in that regard, which all—
So that testimony all goes to Mother's frustration with the department, but where's the testimony that the mother injured the children or that the children weren't safe with her? Is there any direct allegation that she abused them other than not taking the infant to the medical appointment?
There is documentary evidence in that regard, Your Honor, and the documentary evidence, I think you're referring to perhaps the domestic violence findings in terms of the injury to the children. In that regard, the evidence is clear that the children witnessed domestic violence in the home. The children had previously been removed from the home out of concerns for domestic violence. There was testimony at record appendix or documentary evidence at record appendix 205 that the children had seen mother getting hit and had felt sad by that. There was testimony that the father had been mean. So I do think that there is a nexus there that the children had been impacted by domestic violence in the household in this case. And I would just note on the unfitness, Your Honors, there were several findings beyond the 3 that mother appeals here that mother makes no effort to appeal that now are uncontested in this case. For instance, it's uncontested that mother failed to visit the children for over a year prior to the start of trial. It's uncontested that mother didn't comply with her service plan in this case. She never took a parenting class. She gave up on her individual therapy because she felt the therapist was stupid. She did not undergo domestic violence support services. And with regard to the 1-month-old missing 5 medical appointments and not gaining weight sufficiently, that testimony is also uncontested on this appeal, that the baby was not thriving in mother's care. And the factual findings that mother does contest are amply supported in the record. It is clear from the documentary evidence as well as the testimony that mother never had a stable home environment, that domestic violence was evident and prolonged through mother's life. There's statements that she made to DCF that are in the documentary records in this case, where mother reported being beaten about the head for a prolonged period of time, which caused her to be unable to remember things like appointments. She never received any sort of services for that treatment.
And you say in your brief around page 18 that the mother wanted to record a meeting with the department, but told that recording was not allowed. Why is recording not allowed? And is that consistent with the recent First Circuit holding that people can record the police when they're in public?
Your Honor, it's a question I would have to follow up on a letter to this court after oral argument. I don't know the rationale behind it. I know it is a department-wide policy that recording is not allowed. When mother was informed that recording was not allowed, she seemed to understand and said she would feel more comfortable to have a third party there as a support system for her. The department was fine with that request and wanted to give mother the opportunity to reschedule that meeting with a third person present. Unfortunately, that rescheduled meeting never occurred. So, mother had a lot of difficulties maintaining her relationship with the department in this case. I can follow up if Your Honor needs more information regarding why recording specifically is not allowed in the First Circuit case you mentioned, if that would be acceptable, Your Honor.
Well, it seems to be a concern because we do allow social workers to testify to admissions by the parents, and we do see parents regularly say that social workers have misrepresented what had occurred. And this woman is saying, I want a basic protection in place, which is, this, for example, argument is recorded and available for the public. So she's saying, I want to make sure we're on the same page as what was said. So I'm trying to understand what the department's interest is in not allowing her to record it.
Understood, Your Honor. And I would just note that that's not an issue that mother has raised or appealed in this regard, but I'm certainly happy to follow up if additional information is needed or wanted.
Well, we do have this concern about you agree we can't rely on the 51A statements other than to set the stage, right?
They're appropriately for setting the stage. That's correct, Your Honor.
And without the mother's testimony, we're really, a lot of what you're asking us to rely on are the statements from the department in the form of the 51Bs, right?
That is much of the evidence in the record appendix that we rely on. But I would just note, Your Honor, that the department did not cite or rely on any testimony of mother that was struck in contrary to the argument made by mother's counsel. And mother also did not point to any.
But it is potentially relying on statements made during meetings where the department has taken away the ability for this person to provide objective evidence in the form of a recording as to what occurred, right?
Perhaps, Your Honor, but Mother hasn't made any arguments that those documents contain inaccurate or incorrect information, and those documents came in and Mother did not object to them.
Right, but Mother is raising concerns about the fair treatment of her.
I understand Mother to be raising due process arguments regarding notice and an opportunity to be heard, but not necessarily that the documentary evidence was inaccurate or somehow misrepresenting her interactions with the department.
Counselor, a Rule 60 movement has to show extraordinary circumstances. Do they have to show that by clear and convincing evidence?
I'm sorry, Your Honor, you just got cut off. I didn't hear the last part.
The Rule 60 movement has to show extraordinary circumstances, but do they have
Correct.
to show that by clear and convincing evidence?
The Rule 60 motion is on appeal. It's subject to an abuse of discretion standard, not and raising to the level, I think, of a clear error to the point of a miscarriage of justice. Here, I would say that the judge had significant discretion to decide that motion, especially as
but she denied it on the grounds that Mother failed to show by clear and convincing evidence that there were extraordinary circumstances. Is that the right standard?
I believe that Your Honor applied the correct standard in denying that motion, and Your Honor at the trial court also denied that motion based on the best interest of the children and an evaluation of several factors. And I do not believe there was any error in the judge's application of that rule.
I'd like you to provide case law that says that you don't grant the Rule 60 motion unless there's clear and convincing evidence of extraordinary circumstances. That is the rule, which it might be. But that was
Your Honor. I see my time has expired. If there are no further questions, I will rest on my brief and ask this court to please affirm.
Thank you. We'll hear from counsel for the children.
Your Honors, may it please the court, Dawn Messer representing the children in this matter. The children waited for 4 years for their mother to make the changes necessary to reunify, but their mother was either incapable or unwilling to recover from a long history of domestic violence or to participate in treatment to stabilize her mental health. By the time of trial, child 1 was 13 years old and had lived nearly half her life with her maternal grandmother. Child 2 was 10 and had been removed 4 times before her 7th birthday. And child 3 was 3 years old and had only lived with her mother for the first month of her life. The evidence was clear that domestic violence and mental instability had a profound impact on mother's functioning. Her mistrust of others made her suspicious of medical professionals treating her children, resulting in missed appointments and change in providers. She was unable to consistently engage in domestic violence and mental health counseling. And according to Mother, her self-esteem was so low that any talking, laughing, or other sounds around her was a trigger. Mother told her DCF social worker that the beating she suffered caused her not to remember appointments or to effectively cope with stressors. She described anger.
What's the site or the where you get that information from?
For that last statement?
Yeah.
It was Record Appendix 205.
So I think that's either a court. That's either a 51B or it's a court notes, right?
Yes, that's a court report, Your Honor. She described anger issues so severe that at times she felt increased pressure in her head and numbness in her body. During visits with the children, Mother was unable to control her emotions, often screaming profanities at social workers and threatening violence. She called DCF and maternal grandmother evil, threatened harm to the father of child 3, and threatened to make a bomb and break all of the windows in the DCF office. Mother was so erratic that in October of 2016, she was no longer allowed to visit with the children at the DCF office. And despite acknowledging the violence that she suffered, Mother did virtually nothing in the 4 years to address its impact on her functioning, and any efforts she made were brief and ineffective. She agreed to participate in a court clinic evaluation to assess her functioning, but then she never followed through and showed up. In the 4 years prior to judgment, mother reportedly made contact with 3 separate therapists, never lasting more than a few weeks with any of them. She never secured housing, and as of the time of trial, mother was homeless. DCF meetings with mother were sporadic and at best, and by the time trial ended, she had not visited with her children in 18 months. The trial judge committed no error in finding mother unfit to parent her children and that their best interest would be served by terminating her parental rights. Nor did the trial judge err in drawing an adverse inference from mother's failure to attend trial to complete her testimony and striking her testimony from the record. Mother knew of the trial dates, was represented by counsel throughout, and simply chose not to participate in the last 3 dates, which spanned over 2 months period of time. In her request, yes.
Did anyone ask the judge to strike the testimony?
I'm sorry, I did not hear that, Your Honor.
Did anyone ask the judge to strike the testimony?
I don't believe that's in the record. Nobody asked.
Can you walk me through the plan? Am I right in understanding that child 2 and 3 are ending up in the same household?
Yes, so child 2 and child 3 are in a paternal relative's household. The paternal relative of child 3. Child 2 is not related to that household, but she has been there the entire time.
And one of them's being adopted and one of them's a guardian?
Yes.
The guardian?
That's correct.
Right. Is there a reason for that? I didn't.
So there's nothing detailed in the record about why the child 3 is guardianship, but the only thing that can be gleaned from the record is that this child was initially placed in DCF custody in the foster home, and then she was moved to her father's home. She was reunified with her father, and then at some point that disrupted, so she returned back to the foster home. So at that point, father was still involved, was still visiting with the child, and it doesn't appear that the goal had ever changed from a guardianship with the hope that maybe he would still be involved to adoption for the 3rd child.
Thank you.
You're welcome. I see that my time has expired, so I will just ask that the court affirm the decision of the trial court, and I will rest on my brief.
Okay, I want to thank you all three. Very well argued case. There was some request for some additional information during Attorney Bahal's presentation, and I'm going to ask you to hold off on that until you get an order from us. We'll discuss it during our ensemble, and we'll issue an order asking for them exactly what materials you want, so any of you can respond who want the opportunity. So with that, we'll take the case under advisement. Thank you.
Thank you, Your Honor.
Ivan on the record.
Thank you. So good afternoon, everybody, and welcome to the Massachusetts Appeals Court oral argument session for March 12, 2021. As you know, we're hearing this argument on Zoom and live streaming it on the Appeals Court YouTube channel. The judges today are Justice Vicki Henry, Justice Joseph Ditkoff, and myself, Greg Massing. Each side gets 15 minutes. There's no rebuttal, and I understand that the town and the defendants, I guess, are sharing their time. 10 minutes for Mr. Brodsky and 5 for Mr. Lampke. Is that correct?
Yes, Your Honor.
Okay. So when you're not speaking, we'll have you on mute. And for those who on video, that means we can still see you. So keep reactions to a minimum. And we've reviewed the briefs and all the materials in this case. And with that, we'd like to proceed. So I'll call the case. It's 20P334, Perry versus Hull Zoning Board of Appeals and others. And we'll hear first from Mr. Perry.
Okay, thank you, Your Honors. I guess the one thing I would accentuate from my briefs is in regard to the local bylaws that come into play for some of the issues in this appeal. And what I would accentuate is I guess the best word, the primacy of the town meeting in determining the intent of any particular bylaw. just as the higher courts, look to the intent of the Massachusetts legislature in determining how a state law will be carried out. The town meeting is the legislature for the town. That's where bylaws are introduced, debated, and adopted, or not. So my point is, if the intent is not specifically in writing, then it requires a measure of common sense to evaluate what is in writing in relation to the circumstances involved and what can be said, to be commonly understood about those circumstances. I mean, in this case, we're talking about how passageways in the town of Hull are referred to in all of the relevant bylaw. That totality brings an understanding of I contend, of any individual bylaw. It's simply, and again, I won't go over everything that I had in my brief, but it simply makes no sense that the town meeting voters intended a different interpretation of differently named passageways in Hull. The interpretation that the appellees in this case are clinging to, by having a semicolon inserted in one of the bylaws. It just, as Spock would say, I mean, it's illogical. So in summary, I would just say that, with respect to the issues I detailed in my brief and the argument that there was error in the land court, I believe that argument is solid and compelling, and it should be reversed.
Can I ask you a question that there's kind of on your common sense theme here? Because I haven't figured it out yet. What is the significance of a street not having a turning circle? Why you wouldn't count? Why you need a turning circle to count that as frontage? That's how the bylaw reads. Streets without, the specific bylaw just reads, streets without turning circles shall not be counted as frontage. Right, and you're saying that we should apply that to ways as well. But why? What I'm saying is the terms. Again and again, the bylaws talk about streets and ways. Sometimes they say streets, sometimes they say ways, sometimes they say both, streets and ways. It's a catch-all phrase meant for any kind of passageway in Hull, because in the town of Hull, there are numerous designations or words used to designate passageways. There are lanes, there are circles, there are boulevards. Indeed, the subject property in this case is on a lane, So I guess that's what I'm saying. It's not a differentiate. The town bylaws taken as a whole or individually do not really differentiate between a street or a way. And if they did, they would have been more specific about it. In this particular case, where we're talking about the issue of a semicolon. Because they don't, and they're not more specific. They don't state, a way can do this, but a street can't do that. That's not how it reads.
Well, if town meeting thought a street and a way were the same thing, then why would they write the word street and way in lot frontage, lot area, lot line front, and street line?
Because I think they're using it as a catch-all phrase. If you look at all of those bylaws, you see sometimes they use the term streets and ways, sometimes they say streets, sometimes they say ways. They're not differentiating between streets and ways. They're simply saying, when we have passage, instead of using the word, if they'd use the word passageways instead of streets and ways, then I don't think there would be any confusion here.
Your bad faith claim, is that only against the town?
I'm sorry. Can you repeat that?
You have a claim for damages for bad faith. Is that only against the town?
That's against both defendants.
What's the basis of a bad faith claim against the owners? What's the statutory basis?
Well, if you read my briefs, you'll see the statements I made in the briefs. I think there was bad faith. I think there was.
There's a statute that says for bad faith, you can get damages against the board. But what statute says you can get bad faith damages against a fellow homeowner?
I'm not aware of any statute that says that. I haven't researched that aspect of it.
Okay.
So I wanted to understand your argument about frontage. You were saying that the frontage needs to be in a line, but I know this is not the facts of your case, but if you had a cul-de-sac that ended with a turn circle, what would the frontage be there? Would it be the edges of the circle, or would it be as if the street continued straight?
Well, I think in some towns it might be, but in the town of Hull, the bylaw is very specific. It states the frontage must be linear, and I believe I cited that bylaw. So they're talking about frontage in a straight line, and the frontage that is claimed in this case is it's not in dispute that it's less than the required frontage of that zoning zoning area in the town of Hull. The required frontage is greater than the actual length of what they're claiming to be as frontage. They're claiming the so-called Road 2 is 69 feet long. That's not in dispute. And the required frontage is 75 feet, linear feet, according to the bylaws. I agree with you that there might be other towns where, something in a circle could be considered frontage.
So is your position that every property in Hull where the road curves doesn't have any frontage?
Well, I don't. That'd be, I'm not sure. Well, I'll just refer back to the bylaw. I don't know. I don't know what would be considered. If there was a slight curve in something, would that be considered nonlinear? My understanding of linear would be from one point to another without making a dramatic turn, but that would just be my understanding of it. All I can do is refer you back to the bylaw itself.
Is there a reason why the Williams couldn't extend the lane across Road 2, across the other road? That's Row 3, I think. Sorry. Yes, across Row 3. Why couldn't they extend the way there and make it 75 feet that way?
Well, that Row 3 is runs perpendicular the other way. Even if they wanted to extend it that far, they have to conform to the requirements of frontage, which is there's no turning circle there, so how are they going to turn around without going onto private property? Even if they use part of Row 3 as an extension, there is no Row 3. The Row 3 has been eliminated by the land court south of where Row 2 intersects with Row 3. So even if they were going to try to use that as part of their frontage, they can't turn around. You cannot execute a 3-point turn, by only making a right turn on row 3.
So assuming, and I know you don't agree with this, but assuming that they can tack together the length of right-of-way 2 and then take the turn onto right-of-way 3, I don't understand your setback argument as to why that would be not meet setback rules. Could you explain?
Well, the setback argument that I'm making is they are claiming that they can use
Uh-oh.
We lost him with 3 minutes and 30 seconds left. I think this is being recorded, and I think we should give him an opportunity to continue his argument in writing if he'd like to finish. And we should hear from counsel for the appellees, and he can watch it on YouTube afterwards. It will be preserved. So because he's not entitled to rebuttal anyway. So I think we should hear the arguments and take the case in that status.
I think it's obvious, but could you just say we can't hear him anymore?
Right.
In case he can hear us.
Right. Well, yes, that's because we've somehow lost our ability to hear Mr. Perry. But so we'll give him an opportunity to complete his argument in writing, and we'll hear from the counsel for the appellees. So, Mr. Brodsky, 10 minutes.
Thank you. Good afternoon, and may it please the court. My name is Adam Brodsky, and I represent the defendant appellees Charles Williams and Anne Bayou. Charles and Anne purchased 12 Maple Lane with the intent to reconstruct a single-family dwelling on the lot. The lot had been previously used as a single-family residence. The prior owners had raised that house, which was located on the western portion of the lot. At present, there's an existing foundation and shed, and Charles and Anne obtained a building permit to reconstruct the dwelling in a new location more central on that lot. Mr. Perry, as you know, appealed the building permit. The Zoning Board of Appeals affirmed the issuance of the building permit, in fact, on 2 occasions, once during the original appeal and second on remand from the trial court, and the trial court affirmed the ZBA's decision. There's no reason to overturn the trial court and reverse the ZBA's decision. First, Your Honors, 12 Maple Lane is a single lot for purposes of Hull zoning. 12 Maple Lane is comprised of Lot 2 and Lot 3A. The definition of lot is provided at section 22-1 of the zoning bylaws, and a lot needs to have a contiguous parcel in identical ownership, bounded by other lots or streets, and used or available for use as a site for a principal building with one or more accessory buildings. Lot 2 and Lot 3 meet all of those requirements of a single lot. Mr. Perry,
but he says, well, there's this right-of-way 3 that bisects or divides the lot, and in that circumstance, you don't get a single lot. What do you say to that?
Right-of-way number 3 is simply an easement over the properties. There's no separate street or road laid out there, and therefore you have essentially 2 non-conforming lots which combined together create one conforming lot under the doctrine.
What's the easement?
Excuse me?
What's the easement?
The easement's an access easement over right-of-way number 3. It's intended to provide access as well as, I believe, utility easements.
So I think Mr. Perry might argue, had we not lost him, that by having this easement where other people can cross the property, you don't really get a unity of lot. You're not
Oh.
adding up these two lots to have this one big area when in fact people can go through.
Well, I have two arguments to that, Your Honor. First, as a practical matter, no one uses that easement. It's an easement to nowhere. Second, nothing my clients are proposing to do interferes with anyone's theoretical access. If you look at the topography of the lot as demonstrated on the site plan, you'll see that the lot drops off significantly. It's up high on a ledge. And so it doesn't, as a practical matter, provide easement. I believe that these right-of-ways were created, some in 1911, some I believe in 1941, when this was laid out to make sure that there were no landlocked lots here. And in fact, 12 Maple Lane isn't landlocked. It's been used as a single-family lot with access, as a practical matter, over right-of-way number 2, which extends off of the existing lane there. And so nothing my clients are proposing is going to interfere with anyone's use of right-of-way number 3 if they chose to do so. As a practical matter, there is no access.
Can you tell me what's the significance of a turning circle? Why would you not count a street if it doesn't have a turning circle?
Your Honor, the Zoning Board of Appeals in its decision did not elaborate on the origins of that provision. I would only be offering conjecture as to the difference. If you're interested in hearing that, I can offer that. I'm sure Town Council may be able to weigh in on that further. But I assume that the reference to street is a modern street, either laid out by the town or adopted by the town that would meet certain minimum requirements to provide access, whereas a way is something very different. And as the trial judge found and the Zoning Board of Appeals found, it's a means to provide passage, a passageway. And that there's no question that right-of-way number 2, which was created by deed, and right-of-way number 3 provide passage or access to the lot.
Counselor, it seems to me you've got to come up with some rational reason to treat an incomplete street in an incomplete way differently in order for this interpretation that the land court had and that the zoning board had to be considered valid. Can you give us one?
Yes, Your Honor. Again, I don't think there's anything like an incomplete way. These are, historic ways that were created to provide access. So there are no standards by which you would have or you could test something as being incomplete, whereas a modern street would have to conform to certain requirements, minimum requirements. And therefore, I can understand the town. And again, this was not articulated by the Zoning Board of Appeals, but I can understand the town being concerned that if you did not complete this street, that did not meet standards, it did not provide access, that the town would have some concerns regarding you developing a lot off of that incomplete street.
Am I correct in thinking that if the frontage was a problem, there's nothing stopping you from creating a turning circle at the end of the lane on your own property, lot 12, and eliminating the incomplete street problem altogether?
We've effectively done that, and Your Honors, I just want to be careful of time. Forgive me, in the heat of battle, I don't know whether you gave me a full 10 minutes or whether it's 15 minutes on the clock, and so forgive me. I don't want to cut Mr. Lampke.
We gave you 10 because you're sharing 5 with Attorney Lampke.
Thank you, Your Honors. We've effectively created a turning circle by locating the driveway on lots 3A and lot 2 as reflected in the existing conditions, proposed conditions plan. The intention is to drive down Maple Lane to its terminus, then continue along right-of-way number 2, which is located entirely on lot 3B, which is owned by Mr. Perry, and then to turn onto, again, the driveway straddles lot 3A and lot 2, and does in fact create that parking turnaround on Charles and Ann's property. If I might continue, I'm sorry, Your Honor.
Well, so do you understand his setback argument with regard to if you have to tack on frontage from right of way 2 and 3, he's making an argument you can't satisfy the setback requirement. And why is he wrong about that?
Because lots 3A and lot 2 are combined in common ownership. They are a single lot. And so you would measure the setback from the lot lines. The westernmost lot line is the westernmost lot line for lot 2. That would then create more than a 100-foot side yard setback from that western lot line, which more than exceeds the 10 feet required as the minimum side yard under the zoning bylaws. Mr. Perry would want us to measure the side yard either from the limits of the right-of-way number 3, or the line demarking lot 3A from lot 2. But again, these are lots in common ownership, and you define yard under the bylaw with respect to the boundaries of the lot.
So he argues that you have to have a linear foot, meaning essentially that it's in a line. Maybe it would allow for a curve, but it doesn't allow for a left or right turn. Why is he wrong about that?
I see no support of that in the zoning bylaw, as Your Honor had mentioned. There are clearly lots in the town of Hull with frontage along curves, whether they be subdivisions or otherwise, and that's simply not in the zoning bylaw to my knowledge. I'm happy to be corrected by town council, but that does not make any sense. My clients clearly have the requisite amount of frontage. I should correct Mr. Perry. Under the first Perry decision some years ago, the rights of the Namiras, the prior owners, were actually extinguished only over that portion of right-of-way number 3 that's on Mr. Perry's lot, and I believe only at the intersection of right-of-way number 1, not right-of-way number 2. And so my clients have the full ability to rely upon right-of-way number 3 all the way to the southern point where right-of-way number 3 intersects with right-of-way number 1. I have another argument that I'm not exactly sure that the extinguishment of rights over those ways eliminates the ability of someone to count that as frontage, but I don't think it's necessary for the court to reach that issue.
Counsel, one technical question. The bylaw that's in your supplemental appendix, is that what was in front of the judge when he issued the order we're reviewing?
The zoning bylaw, Your Honor?
You've given us a part of the zoning bylaw in your appendix. Is that what the judge had when he issued the decision we're reviewing? Or
yes, we provided a complete copy of the zoning bylaw to you, as well as with our summary judgment papers. And Your Honor, I just want to make clear that Mr. Perry never pled any bad faith claim against my clients, and simply not alleged in any of the pleadings. The claim has always been pled against the board. Thank you for your time.
So one further question, though. He does argue that you lied to the zoning board. Could you address that briefly, because we are past your time?
Thank you, Your Honor. And I did file a motion to strike those allegations as scandalous. Aside from them being false, there's no basis in the record to support them. They're allegations without any evidence, and designed really just to impugn my reputation, which I hold dearly, which is why I asked the court to strike those from his brief, and I'd asked the court to strike those repeated allegations in his opposition to my motion to strike and his reply brief, because again, there's no evidence in the record to even suggest that I did not tell the truth to the zoning board. But I'm telling this board, I categorically deny those allegations.
We'll hear from Attorney Lamke. Mr. Perry, can you hear us again?
I can. Yeah, I came in late, so I don't know how much of Mr. Brodsky's comments I heard, although okay. I guess I'm not allowed to comment at this stage of the proceedings. So.
Although, yeah, no, you'll have an you'll have an opportunity. You certainly have an opportunity to watch the broadcast on our YouTube channel, and we're going to give you we're going to give you leave to file any additional letter you might want to complete your argument.
I would like that. Thank you very much, Your Honor.
Okay, and we'll hear from Attorney Lampke for 5 minutes.
Yes, good afternoon, members of the panel. My name is James Lampke. I'm town council for the town of Hull, and I represent the municipal defendants co-appellees in this matter. Similar to what was done in my brief, I will adopt the argument of the co-defendant appellees, but will also address briefly the particular issues of the alleged gross negligence, bad faith, and malice claim made by the plaintiff.
So before you get to that, I want to be clear. So the town of Hull now agrees that when the bylaws say street, it does not mean way. And when it says way, it does not mean street. And that's not just for Mr. Perry, that's for everybody who lives in the town of Hull, no matter how the ball bounces after that.
That would be correct, Your Honor. That was an interpretation by the Zoning Board of Appeals. And it's always subject to some challenge or some change based on additional law or facts. But I would expect them to be consistent with that interpretation on any other cases until either town meeting changes it, or until a court changes it, or until some compelling argument is presented.
So, well, what you say changes the bylaw or just gives a new interpretation? Because that, of course, is our concern, that everybody's got to live by the same rules.
Absolutely. The board should be continuing to interpret that bylaw as they did in this case.
So he argues that if a way is not a street, then 12 Maple Lane is not even a lot because it's not bounded by a street. What do you say to that?
Well, I adopt the argument presented by the co-defendants of appellees that under the zoning and under the way that that land is laid out, it does have sufficient frontage to meet the requirements of the bylaw.
Right, but he's saying is it on a street?
It's on Maple Lane, which
is a right of way.
Well, Maple Lane is still a street in the town of Hull, to my knowledge. I haven't researched the creation of Maple Lane, but it is used as a street. There are other houses on that.
So I want to be clear what we're talking about. We have a map that shows us right of way 2. Is that what you're calling Maple Lane?
I'm sorry, I don't have the map directly in front of me. I can get it from the
supplemental appendix, page 4.
I apologize. I'm not finding.
It seems, I'm looking at it, seems like Maple Lane seems to end at right of way 1. And then that turns into a right of, we're no longer on Maple Street, then we're merely on rights of way. Does that sound about right?
That would sound about right, but I must confess I'm not conversant on that issue as much as Mr. Brodsky would be.
So Justice Henry, so it's fronting on, it's not fronting on a street, it's fronting on a way. Does that, so your question though was.
So then it's not a lot according, the argument is he's making is then it's not a lot. And so it can't be a buildable lot. I have no idea whether that's right or wrong, but if it's not on a street, then is that a problem?
I don't believe that under the way that the bylaw has been interpreted, that it is a problem, because we do have properties that front on a way and they are treated, they meet other requirements as a buildable lot, and a building permit could be issued for them.
Well, but he's saying that if a way is not a street and a street is not a way, you got to take that all the way through the bylaw, and he would be right about that. And he's saying that the bylaw says for a lot, to have a lot, it has to be on a street, which would then mean it can't be on a way.
I believe he's incorrect in his interpretation. if I may continue with the remaining time, the basic presentation from the town is that there's no basis in the record for the allegations of bad faith, malice, or anything else in his brief. And therefore, the burden is on him to present evidence to that effect. The record is devoid of any evidence, and I do not think that the appeals court needs to tarry long on that issue. There's no evidence to support it. And I've also provided, and I refer the panel to my brief, that the definitions of gross negligence, bad faith, and malice, even if what he says occurred, would not meet the definitions of those terms. But the main issue is there's absolutely no evidence in the record to support his accusations of that nature. And therefore, I believe that as relates to that, the court should uphold the decision of the land court, where similarly there was no evidence in the record to support those allegations.
Okay, thank you. So actually, I'm going to call an audible here, and I hope I don't live to regret it. But we have you on the line, Mr. Perry?
Yes, I am on the line. Yes.
So you cut off with about 3.5 minutes left, and we gave counsel a little bit more time here. So if I'm going to give you a choice. You can respond to us in writing what you haven't said yet, or I'll give you another 5 minutes right now.
I would rather review all of what I very definitely contest many of the statements made by Mr. Brodsky, also by Mr. Lampke, but I would like to, get them in their entirety. So if you can set a deadline for me to send this in by writing, I'll be happy to conform to it. But I'd like to look at the. I guess I can see this on YouTube or something like that.
That's right. So
okay.
So we'll do that. The panel will confer and come up with a date for that, and we'll put something in writing. So
okay.
Thank you all for bearing with us. Interesting case, and we'll take it under advisement.
Thank you very much, Your Honors.
Thank you, Your Honor.
We are live and on the record.
Thank you. So good afternoon, counsel, and welcome to the Massachusetts Appeals Court oral argument session for March 12, 2021. As you know, this argument is being held on Zoom and live streamed on the Appeals Court YouTube channel. The panel for today is Justice Vicki Henry, Justice Joseph Ditkoff, and myself, Greg Massing. We will follow the same rules and customs as in the physical courtroom, except you may remain seated when you're speaking if you prefer. Once we get going, the session clerk will display a countdown clock. Each side gets 15 minutes, but the defendants' appellees have divided their time, as we've discussed before. You're welcome to use all your time, but there's no penalty if you finish early. And when you're not speaking, when it's not your turn, you'll be on mute, but we want to still be able to see you to know that you're still with us. At the same time, that means we can see you, so please keep your reactions to a minimum. The proceeding is being recorded and archived, so it is and will be accessible to the public. As you know, this is an impounded case, so please let's not refer to the father by name or the children by name. Let's become as we can say oldest child, youngest child. And as always, we've read your briefs and we're familiar with the case. In fact, we have your briefs and the record materials in front of us on our different screens and tablets. So if you see us looking away, it's no disrespect to you. We're not looking away from you still have our attention, just we're looking at case materials that might not be directly in front of us. So with that, I'll call the last case for this afternoon, which is Department of Children and Families versus Father, 2020 P 555, and we'll hear from Attorney Fabish.
Good afternoon, Your Honors, and may it please the court. Your Honors, this is a case about stigma and speculation. Stigma from father's prior conviction for exposing himself, and speculation that father's projected approximately 11% recidivism rate may at some unspecified time in the future make him unavailable to parent his daughters.
Counselor, I hate to stop you this soon, but it looked to me like the 11% was based on a score of 4, which was only based on your client not telling the doctor about his prior convictions, and that the testimony was that it was higher once you get up to a 5. Is that not correct?
Your Honor, I do believe that there was testimony about that from Dr. Guidry during the proceeding, and she had indicated that even with the higher level, and I apologize, I'm looking for the record site right now, even with the slightly higher level that might be indicated, if in fact that were the case, that his level of recidivism was still in the same category of above average. And what's important about the trial court's understanding and reliance on that above average determination based on the static 99R evaluation is that the trial court completely fails to consider the context for that evaluation.
Well, could we break this down? Does the father, is he challenging whether the department is correct that the father did not disclose his full criminal record to the doctor?
Your Honor, that's not expressly challenged in the materials or in the brief. And fundamentally, Your Honor, I don't believe that it impacts the result. Because again, there was questioning at trial, both as to whether the score was 4 or as to whether the score was 5. I believe ultimately Dr. Guidry indicated that she did believe that her evaluation was correct as presented. And there were modifications that the trial judge made on the record that clarified and specified that I believe it was the 5. I believe that would be located in Record Appendix 328, Your Honor.
So the department argues, though, that so basically that the judge noted this, but that the thrust of the judge's decision was really that the father was not rehabilitated, didn't have a realistic plan for parenting, and was generally not capable of parenting these children. So why are they wrong about that?
So they're wrong about that for a couple of reasons, Your Honor. First of all, father would suggest that the overwhelming focus of the trial court's decision was in fact focused on the sex offender conviction. And as is noted in the brief, there are 2 reasons why that's problematic, but I'll return to those later if Your Honors will permit, so that I can more specifically address Your Honor's question. As to the trial court's conclusion that father is unavailable to provide a stable or continuous environment for the children, father suggests that conclusion is likewise unsupported for a number of reasons. Primarily, father's understanding of the trial judge's decision is that conclusion was reached in large part based on father's contacts with mother. But father had limited contacts with mother, and in fact, on a number of occasions had expressly imposed boundaries on his contact with mother, such that the few contacts per year that father was having with mother, plus the combination or that in combination with father having called the police to have mother removed from his home, and on another occasion having kicked her out of his home, suggests that he is capable of implementing boundaries with mother. Moreover, the trial court never made an actual finding, and father made no representation that he would leave the children in the care of mother. And thus, even if father had some interactions with mother with the children present, there's really not much, there's nothing in the record to suggest that contact would be harmful to the children or would be on any sort of an ongoing basis. Similar to the situation that you might see in a probate court, father would have control over the amount of contact that would go on, and mother would have her rights terminated. So there's really no risk of mother being in a caretaking role such that that's of concern or detriment to the children. The trial court also looks at a number of other factors when reaching that conclusion. The trial court is concerned about father's lack of expert, I would suggest expert knowledge as to what restrictions are imposed upon him because of his sex offender status in terms of presence on school property or in other places that the children might be. This is a complicated question and one that that requires some degree of legal expertise and analysis in order to reach. But I would suggest that in today's environment and situation, where we have walking available to bring children to school, we have reliance on busing, and most importantly, the entire Commonwealth has just spent a year of remote learning via Zoom. That father,
isn't the problem not that he didn't know the answer to that, but that he didn't even try to figure out the answer to that. He hasn't tried to get any plan on how the children will be taken care of because he's working, nights and working when they would be home, and then he really has no plan, despite all this time, on how he's going to take care of the children. Isn't that the problem?
with respect to the, Your Honor brings up an issue with respect to father's third shift schedule and working, and we also contest the use of that schedule and this supposed lack of plan as evidence of unfitness. And that's because that is an ongoing and evolving process. So what father did do, father successfully developed a daily schedule for the children. That was in the court's findings at 125. Father identified a wide network of potential caretaking supports, including his mother, a nanny, or a friend. Father had demonstrated the ability to work a consistent third shift schedule, despite apparent struggles to sleep and an ability to meet with DCF and adjust his schedule in order to attend classes. So as individuals' lives evolve, as new challenges come in, they can adapt these situations, and father demonstrates through those actions an ability to adapt. The trial court also erroneously discounted father's program completion of most elements of his service plan. And a parent service plan completion need not be perfect in order for a parent to retain parental rights. So in contrast to the few things that father did not complete, father attended therapy once per week and signed a release for the department. He maintained a clean and appropriate home.
I thought nobody could get in contact with the therapist or the therapist supervisor despite many efforts.
The court did make a finding that he did attend in finding 124, Your Honor.
It also found nobody could find out what the qualifications of this doctor were, despite many efforts to talk to this doctor, who we're assuming is a doctor, and the supervisor using the numbers given by your client. Is that not right?
I believe that's accurate, Your Honor, but again, the court did find that he did attend and credited father's testimony relative to that piece.
But if we don't know what the qualifications of this doctor are, what does that get us?
I think it gets, we may not know the exact qualifications of the service, but we know father has engaged in a service. This is a service that was at CSO. So this is not a random service that father picked up. This is a service that was part of his discharge plan. And we have that as one of many other services that father had completed, including, attending Alcoholics Anonymous.
What's CSO?
I apologize. I need to look at the accurate acronym, Your Honor, in order to.
We can figure it out.
But is it correct that when father said he could ask his mother if she would come from out of state for the summer, that he had not in fact asked her if she would be willing?
Your Honor, I don't recall from the record whether or not that is accurate. I would suggest, Your Honor, that it's not particularly relevant, though, because again, the issue becomes as father regains custody, or as an individual has to make caretaking arrangements for children, they would engage in the process. He had a process at play in his mind. I
recognize that sometimes the department puts people in a dilemma because you don't have the 2-bedroom apartment because you don't have the children yet. But here, where he's got to have at least some outline of a plan, he hadn't actually, that's what I'm trying to confirm, whether he had actually asked his mother or not if she was a resource.
Your Honor, I don't recall whether or not there's evidence in the record of that specific fact. However, I would suggest that we have evidence that father had completed the daily schedule plan. We have evidence of father identifying these potential individuals as caretakers. And we also know that as father regained custody, additional resources and supports would be made available to him through the public welfare system that would help him to identify potential daycare slots, that would help him to be able to potentially have an enhanced income, or otherwise work a shift that was not a third shift. And so to focus on these aspects, which are potentially transitory and certainly subject to change as the needs to care for a child are considered and brought into the picture, certainly I would suggest fails to rise to the level of a grievous shortcoming such that it puts a child's welfare much at risk. These are issues.
The child, I think, has represented in the children's brief that the mother is now deceased. Is that, do you agree with that?
Your Honor, I believe that's outside the record. I don't believe there's any record evidence of that fact.
The child's brief also says that the father has not followed his experts' treatment recommendations to mitigate his risks of recidivism. What do you say to that?
Again, with respect to that, Your Honor, the experts' analysis was concluded shortly before trial. I don't believe there's trial evidence that that indicates whether father is likely to have followed that or not followed that in the wake, or given an opportunity to do so, other than, again, to suggest that, as outlined in my brief, father did complete 12 services that were on his service plan, and did indicate, and if you look at some of Dr. Guidry's testimony, Dr. Guidry does indicate that though resistant and at times rigid in his thinking, father is adaptable and does come to appreciate, for example, the wrongness of his conduct. That's in her report. And that brings us back to the question of father's availability and the court's reliance on father's either status as a sex offender, for which there's no case law in Massachusetts that suggests that it's appropriate to terminate parental rights merely because of sex offender status. And in fact, I've cited a number of cases in the brief that suggests that the evaluation process that's used to determine whether or not somebody is likely to reoffend is not equivalent to a determination of unfitness, and should not be relied upon on those in those cases.
In many cases where the judge relies on a father's or a mother's criminal record as being a factor held against them, I mean, why is that any different here?
Because, Your Honor, while it's appropriate for a court to consider a criminal record, in this case, father's read on the trial court's decision is that father is found to be currently unfit because of prospective future possible criminal incarceration and unavailability based on that. The evidence here is that father shows no prurient interest and has no sexualized interest in his children or his daughters. And so he presents no direct risk of harm to them. The only risk of harm that could be identified is the absence of father from their lives at some unspecified point in the future. And if the court sanctions this approach, if the court permits this approach that says that an 11% risk of recidivism is enough to terminate parental rights, then given the reality that the Supreme Judicial Court has expressed that sex offenders are actually less likely to recidivate than normal general criminal population, and also that you can never completely eliminate a risk of reoffense, that degree of speculation fails to satisfy both either a preponderance or a clear convincing evidence standard of evidence. It's simply not enough. And when that is taken out of the picture, as father believes it must be, the remaining issues, though possibly legitimate issues for the court to contemplate, do not rise to a level of grievous harm or risk to the children. And so based on those factors, unless the court has any additional questions, father would rest on his brief and ask the court to reverse the decision of the trial court, vacate the decree terminating father's parental rights, and remand the matter for further proceedings.
Seeing none, thank you. Thank you for your argument. we'll hear from Attorney Jacomar representing the department.
Thank you, Your Honor. May it please the court, Special Assistant Attorney General Arjun Jacomar for the Commonwealth of Massachusetts and the Department of Children and Families. The juvenile court found that father was unfit to parent the children based on a constellation of factors that, taken together, provided clear and convincing evidence of unfitness. That finding was not clearly erroneous, and this honorable court should affirm. Specifically, the trial court emphasized father's history of violence and sexual offenses, the lack of any apparent rehabilitation despite extensive treatment and incarceration, continued extremely poor judgment in his relations with women, his absence from the children's lives and failure to be a consistent fatherly presence in their lives even when he was involved, his lack of contact with the children after his arrest, his lack of a realistic plan to create a stable and continuous environment for the children, and his continued relationship with mother despite her alcoholism and the danger presented to the children.
So counsel, go ahead.
So counsel, on that last one, what do we do with the fact that mother is dead? I mean, maybe the answer is we pretend that's not a fact. And that's one of the factors that he's going to expose her to her, and now she's gone.
Your Honor, that is what the Commonwealth would recommend for two reasons. First of all, it is not in the record, and
which one?
It is. I'm sorry, Your Honor.
You recommend, but which one do you recommend? Ignoring it?
Yes, that's correct. Both because it's not in the record, and perhaps more to the point, it is not raised on appeal by father as grounds for reversal. In any event, we can touch on this in more detail, but the Commonwealth's position as far as the relationship with mother goes is that the trial court's findings were not simply based on a risk of what might happen if mother remained in the children's lives. In fact, the trial court's findings and conclusions of law regarding mother also revolved around what the ongoing relationship with mother and father's view on her potentially seeing the children reflected about his judgment. And that finding we believe is still relevant, still highly relevant to this day. So with
Father argues that there's an overwhelming emphasis on whether or not he might recidivate. Should that even be a consideration?
Your Honor, we would say it should be a consideration. However, as I believe you noted during father's argument, the Commonwealth has a very different perspective on how central the risk of recidivism was to the trial court's findings and conclusions of law. And I believe you characterized it correctly, or our position correctly, at least, when you stated that the real issue here is not so much the possibility that, in fact, is not at all the possibility that he might be incarcerated at some date in the future. In fact, the fact that he has a heightened risk of recidivism is sort of ipso facto representative of the fact that relative to the average sex offender, he is less rehabilitated, and that the aspects of his personality that led him to offend in the first place are still present in the trial court's view. And we think that that was a reasonable holding, that his above average risk of recidivism bespeaks a lack of rehabilitation and continuing shortcomings in judgment and thinking. And as the trial court said, he's failed to demonstrate at all that he has at all been rehabilitated.
What are the rules about level 2 sex offenders going to schools?
Your Honor, I think again, Father, I believe, correctly characterized the rules of trial when he stated that it varies by jurisdiction. And I think that is actually a trenchant point, which is to say that, as Father stated at trial, he hasn't done his homework as to whether he can attend schools in various towns in the Commonwealth, whether he could do so at Cheshire Adams, he was living in Cheshire at the time, as I understand it, whether he could do so in Pittsfield, where he stated at trial that he was thinking of buying a house. And I believe the court sort of characterized this issue correctly during Father's argument, which is to say that it really bespeaks a failure to plan, a failure to do his homework, rather than more as much as anything else. And we think it's trenchant that he did know at least the basic rule that, the basic principle that the rules on schools vary by jurisdiction, vary by town.
He did or did not know that, did you say?
That he knew that they varied by town, but he did not know what the rules were in any of the town, in the town where he was living, in the town where the children were in school, in the town where he was considering buying a house. He was generally aware of the principle, but hadn't done his homework as to the specifics.
So are we sure the judge applied the correct standard when the judge finds that it's been proven by at least a fair preponderance that the child, that the father is unfit, the mother is unfit, and that they're both likely to remain so? That should be clear and convincing, right?
It absolutely should, Your Honor. And but we are, at least the Commonwealth is quite comfortable that in the end, the trial court did apply the right standard. As Father acknowledges in his brief, the reference to a fair preponderance of the evidence is really more likely a Scrivener's error than anything else. We note that in that same paragraph in conclusions of law, the trial court first articulated the standard correctly, stating, in a care and protection proceeding, taken together, the facts must prove parental unfitness by clear and convincing evidence. And it's quite clear that the trial court found that the facts taken together more than met that standard. The court went on to state, after erroneously referring to the fair preponderance standard, that father is extremely likely to continue to be unfit into the indefinite future to a near certitude. Now, a near certitude is well beyond the clear and convincing evidence standard. It's really closer, if anything, to beyond a reasonable doubt. So, we think that certainly that is a Scrivener's error, or just a mistake of the kind that we all make, but not reversible error in this case, because it's quite clear not only that the trial court knew what the real standard was, but that it found that the facts more than met the proper standard.
So on this issue about the father and his plan where he works the third shift and, whether he's lined up childcare, it's very difficult to line up childcare when you actually have the children. So lining up people to say they'll care for your children if you have them at some indefinite date in the future, seems like we're putting him in a ridiculous situation which almost nobody could meet. Although maybe if he had asked his mother. So how are we supposed to evaluate that? I mean, put it another way, maybe less loaded. Like, could the trial court hold it against him if he hadn't found a 2-bedroom apartment for children that he did not have? I mean, because it would be arguably unreasonable to require someone to go get an apartment for children they did not have, when if they got the children, then they would go get the apartment.
Your Honor, I would agree with you that a parent in this situation is to some degree put in a difficult position because they are being asked to make plans based on a conditional circumstance, on the possibility that something might happen in the future. That having been said, Your Honor, I do think there's a difference in kind between finding a 2-bedroom apartment, for example, and figuring out what you're going to do if you take custody of the children when you work 4 nights a week. And but to address one issue that I think came up during Father's argument, it is the case that Father had speculated I could contact my mother in Arizona and ask her to come out here, that he had not, but he did not even broach that subject with her. And he had discussed the possibility of a friend taking care of the children on occasion, but it made no realistic plan for 4 nights a week. And 4 nights a week is at night when the children are under the age of 10, alone in the house, or at least one of them is under the age of 10, is a serious childcare issue, and one that at least needs to be thought through somewhat thoroughly before the time of trial, as opposed to being a sort of spur of the moment issue where, and if you go through the trial transcript, the father ultimately comes out on the idea of, I'll probably hire a nanny, and you know how much that'll take? Probably all the money I have. So we understand that it is a difficult position to put somebody who works at night and seeks to be a single parent, that it puts them in a difficult position to come up with a childcare plan on limited funds. But as far as the children's welfare goes, the Commonwealth believes it's a very important issue. I see that my time has expired. So with that, for the reasons stated in our brief, we would simply urge this court to affirm.
Thank you. We'll hear from Attorney for the Children.
Thank you, Your Honors. May it please the court, Erin Bradbury for the children appellees. This father is unfit to parent these two girls because he is a level 2 sex offender and has not been rehabilitated for his sexual disorder. He's done very little to improve his standing to parent these two girls. This father targeted unaccompanied women in a remote location on a rail trail. He then exposed himself and masturbated in front of his victims. He did this at least 20 times by his count over the course of 2 years. He was doing this while he shared custody of the two children with the mother. He said he did this to try and get a date, and he believed that the women consented and enjoyed it. He said that he felt a rush from the thrill of exposing himself in public. His accounts of his behavior are disturbing. The last day before he got caught for exposing himself, he reported he woke up, he was aroused, and he went to the rail trail. He said, quote, "I found a girl. I made her look at me, but she was different from other girls. The others were interactive. She was not interested, and he still exposed himself to her on 3 times. He described his female victims as consenting, but if you read the victims' statements that are contained in the trial record, they clearly state they were frightened, they were scared of sexual attack, they were worried that no other people on the rail trail would be able to hear their calls for help. Father was found guilty on 5 counts of open and gross lewdness and 1 count of intimidating a witness. He was sentenced to 18 months in jail. He served 13 months, during which time he did not see the girls at all. He did not see the girls from March of 2016 until April of 2018. After his incarceration, Father's thinking about his sex crimes continued to be distorted and impaired. He continued to think that while his acts were illegal, they were not wrong. He disagreed with the law against exposing himself in public. And his sexualized conduct continued after his incarceration. He testified at trial. He was investigated while he was in jail for suspicion of having a sexual relationship with a therapist that worked at the jail. After his release from jail, he showed sexualized dance videos to his DCF social worker, a female, and attempted to get her to dance with him. And then just before trial, he told his own expert witness that she was pretty. She corrected him to say, "It's not appropriate to talk to me like that." And then he did it again. So the crux of the issue here is not so much Father's status as a sex offender, but the fact that he cannot contain his illogical thinking, his distorted thinking. He has not had any treatment that is relative to his sex offender status. And the wrinkle here, as explained by his expert, is that Father presents as though he is on the autism spectrum. And she opines that because of that, he will need a therapist who is versed in dealing with someone with a neurodevelopmental disorder, because it will take quite a lot of therapy to get through to Father. The trial court did not err in finding that Father poses a risk of harm to his daughters and that it is unsafe for him to be unsupervised with them. Father only stopped by his own testimony because he got caught. Turning to his failure to disconnect from the mother, the trial evidence developed showed that the father just cannot comprehend how the continued interactions between mother and the children were harmful to the girls. Trial court found that the mother essentially abandoned the girls. They were exposed to a lot of trauma while in mother's care, and yet father saw nothing wrong with his continued relationship with the mother. With respect to his most recent contact before trial started, I believe he testified at trial that she was staying with him up until the week of trial. He reminded mother that court was coming up. He asked her if she wanted a ride. And so that factor alone also supports a finding of unfitness as to this father. Father's lack of a child care plan that there has been quite some discussion today really shows the futility of it all. Father just is looked at for his ability to parent at that point in time, at the time of trial. He just had no plan.
Sorry, I'm gonna have to ask you to wrap up.
Thank you, Your Honor. And for these reasons, we are asking that the court affirm the trial court's decision to terminate father's parental rights and allow the girl's adoption to proceed.
Okay, thank you very much. Thank you all. You know, I apologize that we made you wait so late in the day. We had a little bit of technical difficulty getting this far, and the arguments just take longer on Zoom because we have to, you know, we have to check in with you beforehand. But so I apologize for that, and I thank you for your patience, and thank you for your briefs and your arguments, and have a great weekend.
Thank you, Your Honors.
And with that, we're going to recess the session. I want to also thank Clerk Ryle for her excellent support today and everybody else behind the scenes who made this possible.